Test. Okay, good afternoon and welcome to docket number 220808, the application of the United Illuminating Company to amend its rate schedule. My name is Chairman Marissa Gillette, and to my left is Commissioner Karen. The Vice Chairman will get himself up to speed in full at a later date. So for this afternoon, we have oral arguments scheduled for approximately 2 hours. The commissioners have read each party and intervener's written exceptions in full. So I just want to go over a few administrative matters at the outset. So first, pursuant to motion ruling number 71, need to emphasize that no new evidence is available to be entered into the record this afternoon. The evidentiary record is closed. So during the oral argument, I would respectfully request that the representatives for each of the parties and interveners make sure to highlight for the commissioner's attention citations to evidence that is in the record, as well as any applicable legal arguments. Additionally, only those who have registered an appearance in accordance with applicable statutes and regulations will be recognized for participation today. This has garnered a lot of public interest, but I do want to clarify that today we're here for an administrative proceeding. This is not a public comment hearing, as we have had many of those leading up to today. Only the speaker will be permitted to engage with the bench, and we ask that you be respectful of the speakers today. Today's event is being live streamed and recorded, as well as transcribed. To maintain the orderly conduct of the proceeding, we will ask that you please help us in abiding by the rules. And if you need to do so, you can exit and watch us on the virtual platform. I want to turn it over to Commissioner Karen for a few opening remarks, and then I will pick it up from there, please.
Thank you, Madam Chairman, and welcome everyone. I'm well aware of the hardworking and talented professional people that make up United Illuminating. It has been my honor to have had the opportunity over the years to get to work with many of you. It is regrettable that the nature of our jobs is adversarial, but I want to emphasize we're not enemies. I would observe that while companies appearing before PURA may feel there is a heightened level of scrutiny associated with our proceedings, it really is that PURA is applying longstanding legal standards in a more rigorous way. Our legislature has taken a more active role in utility matters, and there's an obligation and an expectation of a higher level of accountability for Connecticut PURA, as well as Connecticut's utilities. These are our obligations that we must execute faithfully. There's an opportunity here post-rate case decision to begin to communicate between all of the relevant partners and stakeholders, parties, as to future expectations. We can develop together a roadmap and perhaps a to-do list of what those expectations are going to be. The authority will continue to look with increased scrutiny and accountability of all proposals, plant and service, incentive plans, et cetera, that they have relatively sound estimates as to clear purpose, multiple quotes, costs, scheduling, milestones, and participation of all stakeholders, so that we all know we'll be singing from the same hymn book in our varied melodies and harmonies. The authority is not trying to be punitive, but only to fulfill our own statutory responsibilities and our obligation not only to trust, but to verify. That, Madam Chairman, I'll turn it back to you and start proceedings.
Thank you. So I want to open by level setting on a couple of procedural matters. For this line of questioning, I will need a representative of the company to approach, and then we'll permit other parties and interveners to be heard on this matter, should you so choose, before we proceed more into traditional oral argument. Attorney Venora.
Yes, Dan Venora from the law firm Keegan Whirling, appearing on behalf of the United Illuminating Company. I'll try to bring it closer. Is that better? Okay.
All right, thank you, Attorney Venora. So I just want to open by level setting on a procedural matter that I have some questions about. The purpose of issuing a draft decision and allowing for written exceptions and oral arguments is so that the parties and interveners have an opportunity to provide legal arguments and citations to record evidence to attempt to persuade the authority to adjust certain decision points in the final So if the commissioners are each approaching this with that open mind and intent to do that, I think with that being said, we recognize that there have been a large number of public comments, op-eds, and media coverage pertaining to the draft decision that fall outside of this administrative proceeding. And recognizing that the comments and op-eds are objecting to the draft decision are primarily from UI employees, contractors, business associates, and they've become notable for one reason, and that they contain, some very remarkably similar talking points, particularly about 3 to 4 points focused on a particular sentence. So I guess let me start this procedural question with a question for you, sir, which is this sentence, particularly that Pura will chill these investments and stymie the economic development they generate. Did the company draft or circulate that language?
Chairman Gillette, I think the company, to the extent people have put in public comment, those are their own comments. And I think the purpose of the oral argument is to not only to inform the commission, but also to present the company's interests in relation to the draft decision. I don't have any knowledge of that.
Okay, is there another representative for the company who can answer as to whether those talking points were circulated or drafted by the company?
I mean, we see comments all the time filed at Pura that seem to be consistent, whether there's other interest groups. I don't think this is a spot where the company's going to put on testimony. We're here to present the argument on the draft decision.
Understood. I'm not asking for testimony. I'm trying to get to the bottom of a procedural matter. So I guess I'll cut right to it, which the reasoning behind this line of questions from a procedural point of view is I'm deeply concerned that the company is jeopardizing the authority's ability to modify the draft decision by engaging in this type of activity, because it's at least creating the appearance that the company is attempting to persuade or influence the authority outside of the proper administrative process. So I'm going to ask about the, if the hypothetical here that the authority changes parts of the draft decision as requested by the company. Does this create a appealable issue on behalf of the Consumer Council or others? How are they going to be assured that the change is based on the record and not this extra outside of the record evidence that is could be perceived as attempting to influence the authority's decision-making here?
In my experience, Pura gets public comment all the time. Just because some of these public comments have come from UI employees who have a right to put in public comment, I don't think the situation's any different than what you would normally encounter during a regulatory process. Your decision ultimately has to be based on the law and on the record, and I assume it would be stated in there. Public comment is public comment, not part of the evidentiary record.
Okay, thank you. To your knowledge, has the company contacted elected officials or sponsored op-eds or other media coverage?
I don't know why that's relevant. If they have, it's part of their free speech rights.
Okay. Do you see what could be perceived as an external influence campaign as potentially putting the authority in a bind or having a UAPA issue?
I mean, to my knowledge, I believe the authority also puts out press releases relating to its decision. So I don't see it's any different.
Do you think we put out a press release?
No, but I mean, in the past, the Pura has used that as a communication device.
Okay, thank you. I appreciate that. I have a substantive question getting into oral arguments I'd like to transition into, but if any party or intervener wishes to be heard on that procedural line of questions before I pick up a substantive line of questions with the company, I would pause here. Okay. Attorney Venora, if I could pick back up with some substantive questions for the company, please. Okay, I just have a couple of level setting questions. I want to make sure that we're all working from the same draft decision. Can you please confirm that the total increase that the company sought through its application was 124 million over 3 years, which was later increased to over 131 million over the same period?
I don't have that. I don't have those numbers right at hand.
Okay. Ballpark, does that sound?
Yeah, I think when we read that summary in the draft decision, that seemed right. The numbers seemed right.
Okay. So also in the draft decision was a statement about what the current distribution revenue requirement is. I think it's in the 347 million to $377 million range.
Yeah, that sounds right, subject to check.
Okay. So a quick back of the envelope calculation puts that at a total increase of over 30%. So I'm struggling with this representation that the company is seeking a 5% increase. And so I'm hoping you can point me to the record evidence that talks about a lower increase.
Well, are we talking about the difference between the distribution rate and then total bill? That might be the reason for that.
Okay, I think it was presented generally as UI seeking merely a 5% increase. So if you think that that's the source of the confusion as compared to a comparison of the increase in revenue requirement to the current revenue requirement, which is closer to a 30% increase, then no.
I'll take that back and subject to check. If there's anything I need to supplement on that, we will.
Okay, thank you. Any questions? All right, Attorney Venora, then thank you. I think I'll hold the rest of my questions for your presentation and perhaps after it. So we will proceed into oral argument, noting the appearances that have been properly filed with us from parties and interveners. So with the company affirmatively requesting oral argument, that puts the company in the first position, please.
Thank you. I'm going to introduce 3 members of our team will come up. We're going to start with some initial comments from Mr. Frank Reynolds, who's appearing as a representative of the company.
Good afternoon, Chairman Gillette and Commissioner Karen. My name is Frank Reynolds, and I'm the president of the United Illuminating Company. I started working at the UIL companies in 1994, and I appreciate the opportunity to address you today on behalf of UI and our employees. As reflected in our monthly filings, UI's rates no longer cover the costs of the investments we have already made.
Excuse me, sir, are those monthly filings in the record? I'm sorry, you said the monthly filings. I'm just not sure which ones you're referring to.
Those filings would be on our, oh, sure. Yeah, I'll defer to Attorney Venora here.
Yes, the monthly filings are in the record. I believe it's late file 26. They go through the end of calendar year 2022.
Okay, thank you,
We're
sir.
referring to the quarterly reports.
Thank you, Attorney Venora. And nor do they cover the necessary expenses to maintain safe and reliable service or support Connecticut's ambitious and economic development and climate change objectives. In fact, our return on equity is below the return on simple debt, so we decided to file a rate case in 2022 to set new rates. Unfortunately, the draft decision, if adopted by the authority, will be extraordinarily damaging to UI. I don't know how else to put it other than this. It will paralyze the company and have widespread impact on our operations. Every aspect of our company's operations will be negatively impacted by the draft decision. It will hurt our employees in their day-to-day work, including compensation for our union and non-union employees, pension, and employee benefits. Quite frankly, it's an attack on the company and its employees who work tirelessly each and every day for customers on holidays, in bad weather, and throughout the pandemic. It will hurt our ability to fund costs we need to run the business, such as contractors, computers, telecommunication devices, and employee training. The company simply cannot run the business without the tools necessary to do so. It will also hurt our ability to support the state's energy policy goals, such as electric vehicle deployment, grid modernization, and distributed energy resources. And ultimately, it will hurt the service that we provide to our customers. All of that will be degraded. The draft decision also suggests a framework in which shareholders and investors will be willing to fund the company's operational investments and capital investments at a return on that investment that is equivalent to the cost of debt. That's not reality. No investor will put additional funds into the company if the draft decision is adopted as is. UI is an outstanding Connecticut company. UIL and Avangrid have made substantial investments and have a significant presence in Connecticut with our corporate headquarters, jobs, and partnerships. But the draft decision sends a clear signal that we cannot recover our expenses and that we cannot invest in our people, plant, and facilities. I implore you, both of you as well as Vice Chairman Batowski, please reconsider the draft decision and take the time you need to craft a balanced final decision that provides the company with reasonable regulatory support. I thank you, and I'll now cede the floor to Attorney Cafaro.
Good afternoon, Chairman Gillette, Commissioner Karen. My name is Larry Cafaro, and I'm one of the attorneys that's part of the legal team representing United Illuminating. I'm before you this afternoon to address only one of the many issues covered by this matter. The issue I'll be speaking about is process, the very process that will result in going from a draft decision, in this case, to a final decision. Process for any organization is vitally important. It's important to the members of the organization, those who appear before the organization, and those affected by the decisions of the organization. The vital importance of process is heightened when that organization is a governmental authority. Whether a legislative, judicial, or administrative body, the process must be consistent, transparent, and fair. The process must be such that even if you disagree with the resulting decision, you still have the confidence and trust in the process by which the decision was made. Confidence that the appropriate time, resources, staffing, and deliberation was given to all decision makers that make up that decision-making body. As someone who had the privilege and honor to serve in the Connecticut General Assembly for 22 years, I witnessed firsthand how my colleagues and I fought to preserve, protect, and defend the process, making sure all members had ample opportunity, time, and the resources to properly study, deliberate, and debate a piece of legislation before we cast our vote. Our concerns with the process of this commission in this case stem from the process observed in another recent case. In fact, it was a rate case that was filed just 10 days before this case. I'm referring to the Aquarian case, which this commission decided on March 15th of this year. I'm not here to discuss the specifics of the Aquarian case, nor this case for that matter. I will leave that up to my colleagues from Keegan Merlin. What I'm here to do is to point out the process of that case and suggest how the commission can avoid making a final decision in this case that is influenced by the expiration of time as opposed to merits. In the case I referred to, like all cases before this commission, it was recorded, and the March 15th regular meeting was a virtual meeting that was video recorded. We have a certified transcript of that meeting made in preparation of this hearing. And if one were to watch the video of that hearing or read the transcript, you would not have to be a regulatory expert nor be aware of any of the facts to tell that the process was flawed. In comments made before the final vote, it was very apparent that Commissioners Karen and Betkowski were not in complete agreement with the draft decision and had many concerns. It was stated that at least one commissioner felt compelled to vote in favor of the decision he had serious concerns with, because if he voted any other way, given the fact the vote was scheduled for the last day for any decision to become effective, the rate increase sought by the petitioner would have gone into effect with no restrictions. One could say that it was a choice of
Sir,
the lesser of two evils.
I-
Yes,
I
Madam
need
Chair.
to stop you. This evidence is not in the record, but more importantly, I need to get right to the point. Are you alleging that UI has been deprived of its due process rights in this proceeding? Is that your legal argument here today?
No, my legal argument is to suggest to this commission that the process that be followed would allow all commissioners ample time to debate, deliberate, research, discuss the matters that are before them in this case. I reference the other case because in my opinion, that did not happen.
In your legal opinion, sir, is this a UAPA argument? Specifically, are you alleging that the company has been deprived of its Connecticut General Statutes 4-176?
Madam Chair? Oh, excuse me, I'm sorry. Go ahead.
I'm just, this is a chance to provide legal argument. So I'm asking you specifically what I just heard you restate is your opinion on the matter, which although we haven't met, I'm not sure if your energy and utility attorney haven't met. Although I appreciate your opinion, I'm asking you specifically for a citation to a legal case that supports your position that that the commissioners have not been afforded an adequate amount of time, or that UI has been deprived of its due process rights.
Madam Chair, I am simply suggesting that process is important in this case. I don't think I need a legal citation to do that. And I'm asking the commission to make sure it takes the appropriate time. It's been evident in the past that that might have not have been the case. And what I'm here to suggest is that the August 25th deadline that has sort of been put upon the decision-making in this case be extended, that UI would waive its right and allow this body, your body, to take more time to make an informed decision.
Do you know if your client had a specific position on lengthening the rate case period from 180 days to 350 days? Because my recollection is at the legislature that your client opposed that. So if we're already at the 350 days at which the legislature has allotted us, what specific legal provision are you invoking to extend the 350 days?
Madam Chair, I would argue that the 350 days is actually put there as a protective right to the petitioner. So they know that whether or not their rate case could be decided in a timely manner. If the petitioner is willing to waive that right for, say, a date in the future, like September 15th, which is what we're proposing, I think they're within their rights to do that, to waive the right that was put in by legislature, I would argue, to protect them so that there is not an unduly lengthy decision to prevent them from imposing a rate increase if that's what they care to do.
Okay, I appreciate that, but we're here for oral argument on the draft decision. And I have to reiterate, are you making a legal argument that UI has been deprived of any of its due process rights? And if so, specifically which ones and why, please?
The legal argument that I'm making, Madam Chair, is that this body, your body, the PURA Commission, is set to make a decision on this draft decision by August 25th. And what I'm saying is we are suggesting you extend that time period to September 15th to give everyone a chance to properly analyze this case.
What specifically do you keep suggesting that the authority has not had a chance to fully consider the case? And I'm asking you to you know what, I'll strike that. Please continue.
Well, Madam Chair, you were right to say, let's get to the heart of it. The heart of it is there is evidence in the past that maybe time and calendar have,
In this proceeding, there's evidence in this proceeding.
in the proceedings of the commission, that we do not want time and calendar to dictate the timing of the final decision in this matter. We want to make sure that all commissioners have ample time to discuss, deliberate, and the proper resources to reach a fair and final decision. And to that end, we are saying that we are willing to waive our right to have this decision made by August 25th and are suggesting September 15th as an appropriate date.
Okay, so that was an argument put before the authority on which we issued a unanimous motion ruling. So I'm going to again ask you if you have any legal arguments or deficiencies in the facts that you would like to present to us today with respect to the draft decision.
All I would say is I believe process is a relevant legal argument in any matter. And I am discussing process and again, asking the commission to take the appropriate time
Okay.
to make an informed decision by all commissioners.
Appreciate that. So let's talk about process. Are you aware of how many public comment hearings were held, or how many in-person hearings were held, or how much time the authority allotted for briefing in this matter? I'm asking for a specific example of where you think your client has been prejudiced in terms of process.
I'm not sure I argued, Madam Chair, with due respect, that my client was yet prejudiced. What I'm saying is, I'm talking about the process between the issuance of a draft decision and the adoption of a final decision. And it might not be enough time for all commissioners to have had the appropriate time to discuss, deliberate, and ponder the draft decision before the final vote. That is simply what I am saying.
Is it your understanding under the UAPA that a draft decision was legally required here?
That is not my understanding, no.
Okay, so if a draft decision was not legally required, then it follows that both a draft decision, oral arguments, written exceptions are all discretionary.
They are, Madam Chair, but past precedent certainly plays a role in this. I think it has been the practice of this commission to have a time period between draft decision and final decision for comments, situations such as this to be had.
I have a final question. I'll see if my colleague does. So, final question from me, sir. If we do not extend the statutory deadline, is it your position that your clients' due process rights are prejudiced by not extending that statutory deadline?
If you do not extend the statutory deadline and any commissioners are deprived of the appropriate time to make an informed decision, it would turn out that would be the case, but I can't predict that.
Okay, so I appreciate that. I think there's some implications laden in there, but I will restate that this is a decision that all of the commissioners take seriously, and I'm sure we will take both the written exceptions and oral arguments under consideration when considering the final decision. Commissioner, do you have any questions?
Not necessarily a question, but I would just assure everyone, the authority has been working with this at this rate case with you all as well. We have all the information. Our staff has already been going through the draft decision, identifying errors, possible errors. And I don't think it's safe to say there will probably be some adjustments. Not quite clear exactly what those will be at this point. But speaking of past precedent, the authority has often made adjustments to other rate cases, certainly in my past 11 years here. So rest assured and confident that the authority takes its duties exceptionally seriously. We want to get it right. We understand there's a courthouse across the courtyard here, and we'd rather our decisions not end up there. If they do, that's fine too, because we can generally justify where we are and why we came out where we did. So I would just point out, deadlines are deadlines. They were deadlines in the legislature. One had to be finished at certain points in time, whether there was enough time to read a bill or read an amendment. And I think 350 days is ample time for us to analyze and digest this rate case. That's all.
Thank you. Attorney Venor, did you want to, I'm sorry, Attorney Caffaro, did
I
you,
will now defer to Attorney Kimball. Thank you.
please?
Good afternoon,
Afternoon.
Chairman Gillette, Commissioner Karen, and Vice Chairman Bukowski. My name is Cheryl Kimball. I'm the managing partner of Keegan Worlin LLP. We represent utility clients in Connecticut, Rhode Island, Massachusetts, New Hampshire, Maine, Washington, D.C., Maryland, and Virginia. Our firm was founded in 1988, and our business is just public utility law. Today, I am privileged to be here on behalf of United Illuminating and its hundreds of employees providing electric distribution service to customers in the local communities in Connecticut. I would like to thank Pura for conducting the hearing today. We greatly appreciate your time and attention to this critical matter. This is the first time that I've ever had to address a Public Utility Commission regarding a regulatory decision that places itself so far above the law. Customers need reliable electric service at an affordable price. When I read the decision, I have to think, why would a Public Utility Commission want to affect such a thoroughly destructive outcome on a local utility where the impacts of this type of decision are so far-reaching and so long-lasting? Among many unlawful decisions, this decision plows over $200 million in infrastructure costs into a big mound at the end of the customer's driveway. That mound is not going to melt or magically disappear. It's not going to be paid for by Avangrid's investors. In fact, due to the credit and equity risk caused by this decision, customers will ultimately pay far more in the future than the little bit that this decision saves them now. With this draft decision, Pura has lost all sense of reality and all sense of the law. The decision does not meet constitutional principles or even Connecticut state law. And this decision dispenses with the applicable legal principles in a very deliberate way. What do I mean by this? Connecticut law provides public utilities with the right to file for an amendment of rates under Section 1619. When a utility files for rate relief in accordance with the law, the utility has the burden of proof for its proposed rate increase on all issues. Pura is correct on this point. However, once the filing is made, the law also places obligations on Pura as to what it can do with that filing. Under U.S. Supreme Court case law and Connecticut state law, Pura must set just and reasonable rates, balancing the interests of investors and customers. The term just and reasonable is a legal term with meaning established by the U.S. Constitution as interpreted by the U.S. Supreme Court. Pura must set a fair and reasonable return. Pura must make determinations on the utility's costs using the prudence standard. Pura must determine the prudence of management decisions based on good faith and reasonableness of the utility's decision-making judged at the time the utility made the decision. Pura must make findings of fact as to whether the utility has met its burden, consistent with Connecticut's Administrative Procedure Act. These legal standards are immutable. No matter what method Pura uses as its rate-making method, it must be founded on these principles. Limiting the company to a $2 million increase when the evidentiary record shows that it will produce a return in the range of 5 to 6%, and I cite LFE-026. It means that the draft decision means that the total effect of these rulings is that there is no reasonable opportunity to earn a fair and reasonable return. It is rendered impossible by the fact that the new rates are unjust and unreasonable. And that is the essence of confiscation, which is an unconstitutional taking under the US Constitution. Individually, the outcomes set forth in the decision are arbitrary. There are no legal standards applied, no weighing of the evidence against those standards, and no subsidiary findings as to why the evidence was weighed the way it was.
Attorney Kimball, I have a question on this line of argument. So presumably when the company filed its application, it did so in conformance with the statutory requirements to file rates that are sufficient, but no more than sufficient to cover the company's operating costs. Would you say that that's a fair and accurate
It is
characterization?
accurate.
Okay, so if that's the case, wouldn't any denial or disallowance by the authority put you into the category that you're asserting now? So if you're saying that the application is the only way in which the company can have rates that are sufficient to cover your operating costs, any disallowance beyond what you've proposed would put you into the category that we're.
I think that you know that between $2 million and $91 million, there's a lot of decisions that can be made. And in fact, as the rate making authority, you do have discretion. PURA has discretion to make reasonable judgments about how it in the end puts the rates together. I think what we're saying is at $2 million, and given the evidence in the record, it does not cover the costs and is not sufficient.
Right, I appreciate that. I don't think that's what I asked, though. So how do you square the authority's obligation to scrutinize an application with, which would presumably allow for a denial or disallowance, with your position that the application represents the amount of money that you need to have costs or have reasonable operating costs? So I'm looking for if there's a line. So I think, you know, if you're saying that there's a line and the authority can make disallowances, but we can't go past some line, what is that line? How would you describe it? What's the legal precedent for that line?
The
And-
legal precedent is set by the US Supreme Court. The US Supreme Court says it is balancing the interests of investors and customers. So when we think about what happened in this case, for instance, we had OCC at one point on brief arguing for 9% ROE and about a $50 million increase. So lots of trade-offs inside that number. The company files a number that it feels is needed for sufficient to cover its operations. You go through litigation, you go through the record, you go through a weighing of the evidence, and the commission makes some decisions. I think what I'm saying today is that there's a zone of reasonableness, and under the US Supreme Court law, there is no bright line. And so I'm not going to answer that question because there isn't a bright line. It's all about balance and fairness and following the rules and following the standards of law. And so here, what I am saying is that when you come to $2 million, an effective return of less than 5 once everything gets done, and you look at the record on what ROEs are in the other New England states, you have fall short of that. PURA has fallen short of that mark.
Is that how
where
you're,
we are.
thank you. Is that how you're defining zone of reasonableness? Is what you do?
I'm not defining a zone of reasonableness. You have to look at the whole order as a whole and all the decisions. So I'll continue because that's what I'm discussing in my talk right now. Limiting the company to a $2 million increase when the evidentiary record shows that it will produce a return in the range of 5 to 6% means the draft decision, the total effect of the rulings in the draft decision is that there is no reasonable opportunity to earn a fair and reasonable return. This is not to say that there isn't evidence cited all over the place, but citing evidence is not the same as weighing evidence. Everywhere the decision says the utility did not meet its burden, the utility did a terrible job, and the utility is only getting what it deserves. But if the utility failed its burden to prove prudent, why is it that the company is not found to be imprudent on any cost element? Everyone can understand that imprudent costs should not be in rates, but here the draft decision does not make any finding of imprudence. And you know why? Because there is no imprudence to find. As a result, the decision creates another world where the utility has allegedly failed to prove prudence, but it is not imprudent. This netherworld does not play well in court, and most public utility commissions that I have seen would strive to issue orders that never involve the court. Court decisions that go against a rate-making agency exist in perpetuity and are cited over and over by boring utility lawyers like me, substantially diminishing the credibility and stature of the agency. And yet we have the draft decision. Excuse me. What does it mean to be unlawful? Maybe this is the zone of reasonableness that we can discuss. When PURA is issuing a decision on a rate case that has come before it, PURA cannot just vote yes or no to determine issues of fact and law. Every cost item and the rate of return needs to be looked at through the lens of the legal standards applicable to PURA as a rate-making agency. This has not occurred here. In the draft decision, there's a standard of review stated on pages 6 and 7. Theoretically, this section would lay out legal standards that PURA will apply in making its decisions in the order. However, this section is manipulated to state only certain parts of the standard of review. For example, at page 6, this section does state correctly that the U.S. Supreme Court has determined that public utilities are entitled to just, reasonable, and sufficient rates. However, this section does not state that the U.S. Supreme Court has defined the term just and reasonable rates to be those that assure enough revenue, not only for operating expenses, but also for the capital costs of the business. Similarly, in the decision, PURA found an ROE of 8.8% is sufficient, but no more than sufficient for the company to cover its capital costs, which is not even the correct legal standard for ROE. In fact, the U.S. Supreme Court has found that the return to the equity owner should be commensurate with returns on investments and other enterprises having corresponding risks. This constitutional standard is omitted from the standard of review on pages 6 to 7, and it is not applied or even mentioned anywhere in the decision. According to the Merriam-Webster dictionary, the word commensurate means corresponding in size, extent, amount, or degree, or equivalent. So 8.8% for UI as compared to Massachusetts, 9.8, Rhode Island, 9.3, New Hampshire, 9.3, Maine, 9.3, New York, 9.2, and New Jersey, 9.6. And I refer to OCC-84, UI attachment 7. Let's talk about operating expense. 28 categories of operating expense addressed in this order. The draft decision rejects 15 categories in whole or in part. For 11 of these categories, the draft decision states the company failed its burden. Did the company fail its burden? Who could possibly know? Whereas the determinations are conclusory, lacking subsidiary findings. In fact, PURA never even actually applies the proper legal standard on any of these expenses. I mentioned earlier, PURA is supposed to determine whether the company presented a preponderance of evidence, showing prudence. What does preponderance mean? It means more probable than not. The word preponderance is used 3 times in the decision, all right on page 7 in the standard of review. The word is not mentioned anywhere in the decision, like in the sections where PURA has determined that the company failed the burden. So I ask you, how does the company fail on its burden if the burden is prudence and there's no prudence review? And if the burden is to show prudence with the preponderance of evidence, and nowhere in the decision is there an analysis of whether the company's evidence constituted the preponderance of evidence on the record for the proceeding. Instead, the evidence is cherry-picked to support the unlawful outcome that PURA seeks to impose. So when you put all of this together, there is no legal viability here. There are many, many instances in the draft decision where conclusions directly contradict prior rulings of the commission. This is not PURA applying long-standard precedents in a different way. The decision departs from 50 years of rate-making precedent, all determined under the same constitutional principles that apply today. The law recognizes that utilities are using private capital borrowed and contributed from investors that must be paid back with the opportunity for a fair and reasonable return. No rational investor will contribute $1 of equity to get a return equal to the cost of debt. Equity invested in a utility is always at risk, whereas debt holders have priority with almost no risk. An unlawful decision like this puts the fate of the agency into the hands of the Superior Court because the decision treats these immutable legal principles as extraneous. I have seen in transcripts for the hearings in this proceeding the premise that, don't worry, this is all going to be fine. The market is going to think it's all okay once the initial pain is over. And I'm saying to you, when the market perceives with the issuance of this second unlawful decision that the fundamental disregard for U.S. constitutional law is real in Connecticut, and that there's no check on this unlawfulness except for a 3 to 5 year court process, Connecticut will be abandoned by utility investors and lenders, as is already happening, and it will take a very, very long time to get it back. Last issue, I want to make it very clear that for a utility, the company is not some type of organism separate from its employees. When you hurt your utility companies, you hurt employees, customers, service operations, reliability, towns that rely on utility tax revenue, and everybody and everything that comes in contact with or depends upon the utility. I have had vast privilege of working with many utilities throughout the Northeast, including Avangrid, and in particular UI. And I will tell you that if you take the time to look inside, you will find the most dedicated, skilled, empathetic, and responsible people you have ever met. These employees truly love serving customers, and you would be amazed at how a utility can ever collect so many people willing to work under such tough conditions for the benefit of customers. I would defy any person here today to put on personal protection equipment that a UI line worker needs to put on and climb a pole on Christmas Day in freezing rain to restore power on high voltage lines as they did last Christmas. It's sacrifice, it's courage, it's dedication. Yet Pura wants to exercise its precious discretion by issuing an unlawful decision telling customers, hey, don't worry, we got this utility good. It's a bad situation. As a legal practitioner appearing in numerous jurisdictions, this is by far the most punitive, unlawful, and ill-fated decision that I have ever seen. And I will leave you with this. The draft decision is irredeemable. It cannot be fixed. There are numerous legal errors through every section. There are hidden bugaboos that will never be sorted out at this stage. The most productive way out of this is a settlement process, which no party will undertake unless Pura directs the parties to undertake discussions and reach a settlement of issues for Pura to consider. With the robust record that exists in this proceeding, this outcome would be consistent with the new provisions of SB 7 for settlements. If Pura cannot find a way to do this, then we request the following. We ask Pura to raise the ROE to a level commensurate with the rest of New England, New York, and New Jersey so that Connecticut is not disadvantaged. We ask Pura to eliminate the spiteful ROE penalties that will deter investment. We ask Pura to restore the recovery of $220 million of capital investment because the system needs that investment, and it is not in the interest of customers to pay later at a higher cost. We ask Pura to eliminate the baseless write-downs of regulatory deferrals, which will cause an immediate $37 million hit to the company, roughly equal to 50% of the company's annual net income on the date this decision goes to final. On behalf of UI and its valued employees and customers, thank you for listening.
Okay. I mean, the bench has questions, so I'm not sure who wants to address them. Is Attorney Venora, I'm going to start with you, sir. So I think somewhere in there I heard an allegation about, I'm sorry, the 5.6% ROE. I'm not sure where that was. So can I start there and ask what that was referring to?
Sorry. Let me give you the site. I think I said 5 to 6%, not 5.6.
Okay.
I was referring to LFE-026, which is the earnings report of December 31, 2022. And that reports a ROE of 6.33%. And all I did for that was subtract the 52 basis point penalty, and it got me between 5 and 6%.
You subtracted it from their earned ROE, not their authorized ROE.
I subtracted it from their actual ROE as of 12/31/2022 to approximate what the minimum impact would be of once this order is issued and on the street.
Okay, thank you. So are either of you familiar with INRI Citizens Utilities Company? It's a Vermont Supreme Court case interpreting Bluefield circa 2000.
I am not familiar with it off the top of my head. I don't find any other case that you are going to cite to be probative of what's happened here. I did a lot of research to come here, to come to this conclusion, and there really has never been a case where the total effect is as bad as this one. So I wouldn't find any other precedent to be probative.
Okay. So INRI Citizens Utilities Company interprets Bluefield by saying the return should be reasonably sufficient to assure confidence in the financial soundness of the utility and should be adequate under efficient and economical management to maintain and support its credit and enable it to raise the money necessary for the proper discharge of its public duties. The case goes on to interpret what that means by under efficient and economical management. I think my question for you or another company representative is, whether the phrase under efficient and economical management is an important qualification that pertains to a commission's ability to impose ROE reductions. And I can stop there and I'll
Of
ask my-
course, Public Utility Commission always has the obligation and the discretion to be looking at the performance of a utility and to be exercising judiciously the range of reasonables that it may get to on ROE. I would say here, you don't have the record for that, unfortunately. And second of all, some of the penalties already have been penalized in other ways through NOVs. So I think that in this decision, you still have to end up in the place of covering the capital costs. And so one thing that's interesting about the order, of course, is that like an Aquarion, both orders, the PURA goes through the exercise of looking at, oh, is this going to affect your credit rating? And goes through the exercise of saying, doing the calculations of cash flow metrics and coming to the conclusion, oh, we can lower ROE, we can lower capital structure, we're still going to be okay. But what PURA hasn't considered in any of that is the impact of the order. And instead of $91 million of revenues, we're now looking at $2 million of revenues. So when you think about whether this decision is constitutional, of course, you have to look at the overall effect, not just some finding on management economy. And you have to end up in the right place. And the problem is here, you're starting at a place that isn't right, 8.8, and then PURA is ending up in a place that's completely punitive and unworkable because there won't even be enough cash to run the business. But that isn't considered in the order. That was things that the outcome that would be discussed in the motion we filed with additional evidence for PURA to look at, and that there has been no ruling on that as yet.
Okay, so, well, there's been no ruling because the company didn't allow for 7 days to happen before today.
Yeah, I'm
But
not surprised it's the company's fault.
So let's talk about that $91 million in the hypothetical. So I guess what I'm trying to get at in my questions is, to back into the calculation and the argument that you're offering,
Excuse me, I'm not offering argument. This is the truth.
okay,
Madam Chair, if I may, Attorney Kimball, it has been my pleasure to work with you for the past 11 years. I've enjoyed you coming into our hearings, our proceedings. Always enjoyed your cross-examinations. You're a very talented attorney. And as an attorney, you know, there's no truth until it's been cross-examined. So your truth is different from my truth, different from his truth, different from anybody else. Depends where you sit in terms of your perspective. And I've always found that you've had a healthy respect for the process and for this organization. And I always appreciated that. And I understand there are some certain passions here. And I appreciate that. But it would have been nice if in your discussion with us, you could have pointed to a few more things besides ill-fated decision, unlawful, illegal. It would be nice to have pointed to a few things in the decision here on
Sure.
page XX, section 6.1,
Yes,
and showed us where we got it wrong.
okay.
Maybe showed us where we got it right. That would be helpful.
But I would like to ask my specific question. So if you're not going to answer it, then I'm happy to ask it to Attorney Venora. And thank you,
No,
Commissioner
please go
Karen.
ahead. That's fine. I will answer it. What is the question?
Okay, so my specific question is pertaining to the revenue requirements. I'm trying to back into understanding the 52 basis point subtraction and how you calculated the ROE, assuming, I think what I heard you say, and please correct me if I'm mischaracterizing this, is that the authority in doing its financial health analysis needs to take into account the revenues that it's not allowing in the proceeding when conducting it. And I guess I'm really struggling with, I'm hoping you can help me with some legal precedent that backs up the position that we would have to take into account disallowed revenue, because if we're disallowing it, and I understand that you're taking a position on the disallowances here, but hypothetically, if there's a disallowance, it is because, the company has not met its burden, or, there's a reason there's a disallowance. So I'm not clear why we would then take into account revenue that has been disallowed or found to be discretionary and not in support of the provision of utility service. So why would that be taken into account when calculating the actual ROE, as I think
Very good question, and thank you for the question. I think, first of all, I didn't say that it wasn't taken into account in calculating the ROE. What I said is that the legal principle is that PURA has to end up in a place where the end result comports with Hope and Bluefield and provides a reasonable opportunity to earn a fair and reasonable return. So we'll just start there. So two different things. When we look at the credit rating metrics, these are measuring cash flow. They don't care, the metrics do not care whether PURA has allowed or disallowed something. Just because PURA has disallowed it doesn't mean that the company doesn't actually have the expense. So let's think about, for instance, incentive compensation. And thank you, Commissioner Chairman. I will give you some more examples. If we think about incentive compensation, so if I'm an employee with incentive compensation, I only get paid, unlike other people in the world, I only get paid maybe 90% of my salary. The other 10% doesn't come till the end of the year. So my paycheck is essentially short 10%. So when PURA disallows 100% of incentive compensation paid to employees, the company still has to pay that expense out. So when I'm a credit rating agency, I got to look at all the flows out of the business and all the flows in. It has no relevance that something may or may not be in rates. The credit rating metrics are not looking at a specific thing. So when PURA issues an order and says, hey, you're financially healthy, we looked at the credit rating metrics and your metrics got some room in them. So if we hit you on ROE, hit you on capital structure, hit you on capital cost recovery, you're going to be okay. But what PURA has to do, and the law I would cite is, you have to end up in a spot that allows a just and reasonable, a reasonable rate of return and a reasonable opportunity to get that return. And if you haven't considered in your calculations that you're taking all the revenue away from the company, then your end calculations of whether you've covered the capital costs of the companies is going to be wrong.
Okay, I appreciate that. So let me, I'll just cut to the chase in terms of my question, and maybe you can see where I'm going with this. Understanding everything that you just said, so I have a hypothetical where a company comes in and asks for $400 million, but everyone agrees that they have justified 100 million. And, so that's what the authority allows. But then the company comes back and says, well, we needed 200 million in order to be solvent. We concede that it was our burden to get you to $200 million. We didn't get there, but you have to give us $200 million so we can be solvent.
I would not agree that the utility would be in that position to say that. So in other words, if the utility came in for 400 million, it's going to come in with whatever it thinks its costs are, and it puts together a case to try to figure out how can I justify to the regulator this $400 million, sorry, in your example. But that utility is also coming in feeling like the law is going to apply. So in the law, the regulator always has some discretion. So the utility will know, I'm probably not going to get 400 million. I'm going to try to get as much as I can by proving my case as much as I can. And I'm going to get treated under the appropriate legal standards. And there will be the requisite subsidiary findings of fact to tell me how the commission got there. So if that utility truly within a perfectly legal, perfect construct came out with $100 million, then something else has to happen. And that's not necessarily the regulator's problem. You would have to understand what's driving cash flow inside this utility. And so it's not like the utility can just come back and say, so sorry, Dad, I need 200 million instead of 100. You would have to analyze that problem to figure out if that was a perfectly legal order that was unappealable, then that's the revenues that's left to the company.
Okay, thank you. I appreciate that. That's really helpful because I'm struggling to reconcile the hypothetical that we just had with the instant, circumstances. And I understand that it's the company's positions that, how I align those numbers to the instant situation, that the disallowances are, you're taking issue with the disallowances, but I think the hypothetical applies here from the legal analysis or the application of that legal analysis here. Because if you're in the authority's position and we put out a draft decision, recognize that we want to take comment on it, but the only argument being presented to us is, well, you have to give us what we asked for, because otherwise it's not a fair result. I think that's what the
I guess, Chairman, I never said that. That is not words that I said. To Commissioner Karen's point, let me give you some examples. How about if that helps?
Okay, thank you.
So let's take the $220 million capital disallowance. We have a couple things going on there, and this is similar to the Aquarion problem. The company comes in, there's say 7, and I don't know, I will just profess, I don't know all the exact numbers. My colleague, Dan, knows more about the exact numbers.
Sure. Can you get me to the page though, just so I can make sure I'm following with your.
It's right at the beginning.
Okay, because when you're saying disallowance, I think where I got confused the first time you said that, and now when you're saying it now, is if it's what I'm thinking of, it's not actually a disallowance. It hasn't been authorized in this decision, but it's.
I think I said there was a couple of different things going on, so let me just go through it. So we have these segments of capital. We have the test year capital, we have post-test year capital, and then we have future capital. And Connecticut, for however many years, over maybe 25 years, has always allowed the forecast of capital through the rate year as a way of supporting utility operations between rate cases with the capital investment. So that's part of that 220 million. And that's a change in rate making policy, which PURA can effect, but not in the case that you're doing it in without any notice. So when the case got filed in September of 2022, the policy was you can include this 1 year of future forecasted capital. Then PURA has always had rigorous checks and balances around that you have to file to prove that you did spend that. So it's never ends up being something that hasn't been spent. And at the time the company filed, the policy was you can get this future piece in the rates. Then the company gets in, and the same with Aquarion. The company gets in, and in the middle of the proceeding, all of a sudden, it's towards the end of the proceeding, we start seeing some things shifting where there's some lists and stuff that are segmenting. Then we come out at the final decision, and that's lost. And not only is it lost, But then the statement is, well, you can decide to file your rate case in a different time. Well, how can I decide to file my rate case in a different time if I already filed it when the policy existed and now the policy changed in the middle of the case? So is that a choice PURA can make? Sure. Have the parties brief it for the next case. Let the company have the chance of putting their projects and everything in order for the next case. But to change the process and the standard in the middle of the case, very, very unfair, no notice, very difficult for a company to adjust to. And then you get to the order and the order says, oh, well, you didn't meet your burden. Another part of this is that, which I actually view as a bigger problem than the first one, is that there's a total amount of capital that has been spent. So you have projects here that are in service, used and useful to customers. Always the precedent for tens of years allows the company to get those up to the close of the record. Very reasonable policy and a good policy because it allows to keep the rates pretty current with what's being used by customers. Here, and in Aquarion, we find out that, oh, we have met the proof for the test year. So $500 million goes in for the test year, and some amount that's post-test year, used and useful to customers, doesn't go into rates. And yet they're using the same proof, the exact same proof. And so now I've found that the proof is okay for one bunch of projects, but not for the next bunch of projects. So that is the epitome of arbitrary decision-making. A regulator cannot rely on the same evidence, find you've met your burden on one and not met your burden on the other. So these are policies. It's just a matter of like patience. If you want to implement this, I will never underestimate the discretion that a rate-making authority has in setting rates, but you have to set those types of rules ahead of time and not change the practice during the case. It's not fair. There's no notice. And now the company has spent 2 years, as has PURA. It's a lot of work. I mean, it's a lot of work. And now you've had 2 years to go through this, and the company's coming out with things that should be in rates stripped out with the statement, you didn't meet your burden of proof. That's not what's going on.
Okay, thank you for that example.
Would you like another example?
Sure, just a moment, but I want to unpack that if I can. I've got a couple of questions about that. I mean, I think we may have to agree to disagree that the recitation you just provided is what the draft decision says in terms of proof and whatnot. But my specific question is it the company's position that ratepayers should pay for investments that are not completed?
I understand that there is a long rate making history of we only put into rates what is used and useful to customers. And that is a very legitimate policy for a regulator to have. There's lots of jurisdictions that don't like future test years, and that's how they would look at it because nobody likes estimates. But one thing that Connecticut has always done so well is Connecticut has taken the forecast in. OCC's always had a good witness who comes in and examines like what the company spent the last time and how the company handled that forecast. And then there's the trust but verify process that says after the effect that you have that in rates, you're going to check on it. And it's a viable rate making policy if you want to allow support for capital investment. If you want to kill capital investment, go ahead, take it out,
Okay,
is what I would say.
thank you. And so just so we're on the same page, do you know if OCC did that this time, the step that you just?
My belief of reading their briefs is that brief before the draft decision came out, they recommended, yes, inclusion of a portion, not everything that the company asked for. It was about $23 million short, I believe, but it did have future capital. And I think that is OCC's reasonable way of trying to not hurt investment, but also protecting customers. Very reasonable place to be.
Okay, all right. Thank you. I think recognizing that it's, we're an hour plus into a 2-hour scheduled oral argument. Commissioner Karen, do you have questions before we turn to some additional parties?
Look, I think I'm good for now and appreciate the fleshing out there. I appreciate that.
I really appreciate, and I just also want to say, we were instructed not to be relying on stuff we had put in our written exceptions. So I was trying to adhere to the rules. So but I appreciate you asking for the example.
Yeah, and I guess what I mean is, this is the opportunity through your written exceptions to point us in your written exceptions into the decision, again, where we got it right, where we got it wrong, and embellish. Here's why we think you missed it. Here's this one we think is good, and it was usually there. You know what I mean? Just,
Yeah, and Matt and the chairman said that it's been read, and we really, really appreciate it because it's not that fun to read.
no.
So thank you.
None of it is, but again, this is the opportunity to show us the most important things for the company that we need to at least address if it hasn't occurred to us already.
Thank you so much, Commissioner Karen. And Chairman, thank you very much.
Thank you. Let's move on to other parties. We will come to the extent that time allows, we'll come back to other parties. So I didn't do my normal creation of the order up front. So I know apologies for taking a procedural step in the middle of it, but I see OCC, I see DEEP as the Attorney General there. I see some parties for some of the poll attachers, Attorney Bogan, Attorney Cook. Am I missing any party that intended to present oral argument? Oh, Mr. Attorney Goodman, I'm sorry, is CIEC. Am I missing anyone else? Okay, if I can invite the Office of Consumer Counsel, since you're right in front of me, then I'll move to DEEP AG. I'll try to circle through everybody. So Attorney Wheel, if you, and Consumer Counsel Coleman, if you would, please.
Thank you. Well, Consumer Counsel Coleman wanted to make a few remarks, so I'll pass the mic to her to begin.
Sure. And I apologize. You might have to kind of tilt it up a little bit.
Good afternoon, Chair Gillette and Commissioner Karen. Thanks so much. I know we're tight on time, and Attorney Wheel is going to respond in detail to the arguments you heard from UI's lawyers, but I did want to take a minute to respond to Mr. Reynolds' opening remarks and some of the concerns, the broader concerns we've been hearing. As the advocate for all electricity customers, my team and I approach this from a perspective of what is in the best interest of customers. These are customers who have been paying incredibly high electricity rates for years. And at the same time, we are evaluating a distribution company that has enjoyed strong returns and healthy profits for years. So we're looking at electricity bills that impact not just our most vulnerable customers in Connecticut, those who can hardly afford to pay for their utility bill along with other essentials, but also our businesses. We know that we have businesses and manufacturing hubs in Connecticut that struggle daily and monthly to pay their bills and often leave the state because of those high electricity bills. So I understand that UI and its parent company has a fiduciary duty to their shareholders to maximize profit. And therefore they have this obligation to be here to wage a strong legal and media campaign against the decision because of the impact or the potential impact on those profits. And as recognized in the draft decision, it's the authority's duty to support the public interest. And we believe that the draft decision does demonstrate a very careful evaluation of the full array of facts and presented by the company, as well as all of the stakeholders and state agency partners, including my office, the Office of Consumer Counsel. I do want to say we support continued efforts to create and continue to have regulatory certainty for the companies. And we have provided suggestions within our exceptions and comments regarding how to create and continue to have regulatory certainty in the context of this transition period we're in. But we are in an important transition towards performance-based regulatory framework. And for that reason specifically, it does not make sense for PURA to lock in even higher rates than we're already paying now for the next 3 years, given we're in this transition, and those rates would not tie to performance. This is especially true given that UI filed an application and presented its case with significant gaps. UI didn't provide an updated cost of service model, which is a foundational element to evaluating any rate application. UI didn't produce the level of information to demonstrate customers would actually be benefiting from many of the capital investments UI was seeking to recover at the time that the new rates would kick in. And UI had extensive performance deficiencies in recent years that were documented by several of the stakeholders that engaged in the weeks long of hearings. There was testimony and evidence of customer service failures, of deficiencies in storm response, of accounting mistakes, of environmental remediation failures that were required under a PURA-approved merger. So while we've heard a lot of highly inflammatory language today about the impacts of this decision, it is appropriate, as the authority has done, to take these facts into consideration. And even if the decision was adopted as is today, UI would still be receiving more revenue after this rate case, not less, and have more staff, not less, to meet its obligations to provide a safe and reliable electricity service. So scrutinizing UI's costs and profit levels, as PURA has done in this draft decision, is necessary. It's necessary to help rebalance that partnership between customers and utility companies that UI says it wants and needs. And we don't have to have, and we need not have an unhealthy regulatory environment, so long as all members of this work, all stakeholders, continue to work together to ensure that we're making investments that benefit customers most. So Attorney Wheel is going to address some of the specifics. As I mentioned, we do believe the draft decision meets all relevant constitutional and legal standards. And I do want to say that, despite its disappointment with the outcome of this case, UI still has an obligation to continue to invest in the electric system, and to do otherwise would break the regulatory compact, which is the most fundamental obligation between the state and our utilities. And I have confidence that UI is going to continue to provide safe and reliable service to all customers, regardless of whether or not this decision changes at all. And UI will also continue to earn profits on investments it makes. And we expect UI to take advantage of the business model that affords it to make profits on the investments that benefit customers. So with that, I'll turn it to Attorney Wheel to go through a few specifics. Thank you for your indulgence.
Thank you.
Attorney Wheel, before you start, I think Consumer Counsel Coleman mentioned you're going to address the company's points.
Yes.
I don't recall there was much comment from written exceptions from the OCC. But are there things in the proposed decision that the OCC has highlighted that maybe we did get wrong or what we did get right? Wouldn't mind hearing some of that as well, if you have it available.
Absolutely. I can start with that. I would say that in total, the OCC vastly agrees with that the decision is correct. There are plenty of areas where, as the authority knows, it differs. It landed in a different place than what the OCC proposed in our briefing or via our evidence. Our analysis of almost all of those issues is that even though the authority may have landed differently than we advocated, we accept where the authority landed. We think the end result makes sense after the authority had weighed the evidence presented by all of the parties and considered everybody's briefing, which is the authority's role. We see our role is to advocate zealously and as strongly as we can in favor of ratepayers. The company's fiduciary duty is to advocate as zealously as it can on behalf of its shareholders. And as the authority knows, its role is to weigh the competing interests of all the parties involved and come up with what makes the most sense. The issues off the top of my head, Commissioner Karen, I think despite everything I just said, the OCC hasn't changed any of our positions as to anything that we did advocate in the case. There are some areas that we think we look forward to maybe other venues where the authority could consider some of the suggestions we made. What I have particularly in mind is our brief touched on for several pages the notion of adopting standards standards for plant and service specifically and capital planning that are similar to what are in place in Vermont. I did read the draft decision to take a different result on that suggestion in the context of this case. I think as we pointed out, as we suggested in our exceptions, we look forward to perhaps extending that conversation to the PBR framework discussions or else, where we would be happy to have conversations about that issue elsewhere.
Attorney Wheel, can I interrupt you? Because I'm not sure if this is the exact, the question I have right now. I'm not sure it's exactly on point to what you are talking about, but also highlights PBR. So in the OCC's written exceptions, one of the first items you address are the use of proceeds from the earning sharing mechanism for storm costs. And so the OCC is seeking clarification in the final decision, and I'm in turn seeking clarification from you about what clarification you're looking for. So it says OCC, I'm reading from your written exceptions, page, 4 maybe. So OCC seeks clarification as to whether any portion of the ESM revenue may be applied. So, but then you go on to support, if I'm reading this correctly, establishing a formula in the reopener for PBR. So my question to you is, are you seeking for us to both in this decision clarify a percentage of ESM revenue and support determination of that allocation for prospective use in the PBR reopener, or is it just the latter? And is that then okay to apply to this decision after it's decided in the reopener? I could ask that more clearly, but do
No,
you follow?
I understand the confusion. I think I can address where we're coming from on that issue. As it says in our exceptions, the issue of using ESM proceeds to pay down some of the storm costs and the regulatory assets, that was proposed by the company. They had the notion of using some share of the customer's share of the ESM to pay that down. We filed a counter proposal suggesting that perhaps 25% of the company's share of the ESM could be used for the same purpose. We did see and sort of wrapped into that, as I'm sure the authority recalls, was in the same conversation, there were some other areas about the ESM specifically. I'm specifically thinking of the appropriate capital structure to apply. And when we reviewed the ESM treatment within the draft decision generally, which touched on those areas, but it didn't seem clear to us whether it seemed clear to us that the authority in the draft decision accepts the notion that a portion of the ESM can be used to apply against storm costs, but it wasn't clear what portion, or it wasn't clear to us whether the company's specific proposals being adopted or some other proposal. And just to clarify.
And by what, I'm so sorry, you're about to clarify, but when you say what portion, do you mean the company's portion or a ratepayer's portion, or are you referring to a specific percentage?
Both, actually.
Okay.
In other words, the idea is you take the ESM proceeds and take something out of those ESM proceeds to apply against storm costs. So it's my reading of the draft decision that the authority agrees that is an appropriate, could be an appropriate use for ESM. But then I'm not sure whether the authority is accepting that the company's proposal that those costs should come out of the customer side is accepted, or some other proposal.
Thank you.
And then for clarification, Madam Chair, to what you were asking before, I don't think that we're recommending necessarily that the PBR proceeding necessarily adopt a formula that's specifically about storm recovery. I think we are more generally saying that maybe this is something, maybe if the authority were to consider adopting some kind of methodology for the ESM for this purpose, that maybe the PBR proceeding, specifically REO 1, I believe is addressing the ESM, maybe that would be the appropriate place to have that conversation.
Thank you. And I apologize, I interrupted you in answering. Did he answer your question? Yeah, okay, so please proceed with your presentation.
Thank you. And I apologize, Commissioner Karen. I think our exceptions do, they're primarily framed as areas of clarification. And there are some mild suggestions in there, but I think that encapsulates the areas, our exceptions encapsulate our reaction in general to the draft decision.
Can I just explore a little bit about the disallowance of the multi-year rate plan?
Yes.
And just going to a 1 year. In your mind, or in case of the OCC, thinking is obviously you agreed with that. You don't think that that's going to be detrimental to the company. Is this an opportunity for the company to come back within the year and perhaps present some of the planned additions and some of the other things that may or may not be added back into a final decision, but they'd have an opportunity to meet the burden of proof going forward?
Absolutely. In fact, that was in our briefing, we recommended that the 3-year rate plan be not be approved and that the authority instead adopt a single rate year for 2 primary reasons. First, because of the ongoing proceeding for PBR, as I was just discussing, which is also addressing multi-year rate plans. And it's my understanding of the draft that the draft decision takes a similar approach in only ordering a single rate year. But we did actually make that second point in our brief that essentially our argument is that there just isn't, that because of the insufficiency in our view of the evidence that's presented by the company to support its among a lot of things, its projected plant, that perhaps what we argued is that it would make more sense to just allow for a single rate year to be certain that the company is able to collect sufficient revenues within that rate year to continue, but then for that exact purpose to be able to come back with a better quantum of evidence to be able to justify what it's seeking on a longer term basis.
Right. And so speaking of that, and I'm reminded of Attorney Kimball's point about the company's feeling that rules were changed in the middle of the proceeding, that would the OCC be opposed to another proceeding wherein we can find a way to set expectations of both the companies before us and the companies of the authority, what they're actually looking for and expecting, and we'll find adequate in terms of a burden of proof, perhaps even in the PBR as a 4-3 opener?
I mean, we would absolutely not be opposed, since that was we would welcome that. I think that's exactly in line with what we've been advocating for. I'm happy to hear that the authority might even consider that. We did suggest that perhaps the third prong of PBR, which is focused on distribution system planning, might be an appropriate place for that. Although I would suggest that would be limited to the kind of singular issue of the capital plan and plant and service. And perhaps, I mean, it sounds to me like there's still an awful lot of confusion over this issue of burden, which I was going to touch on. But maybe these overarching issues about the expectations, the filing expectations in a rate case overall we'd certainly welcome a broader conversation about that. And I think that would make a lot of sense. Well, and I'll just transition right there to reacting a little bit to Attorney Kimball's remarks about burden. And this is probably going to sound familiar to the authority because it's very similar, I think, to what I suggested in my oral argument in the Aquarian rate case. And that's that we don't read the draft decision to be, I think Attorney Kimball was correct actually in identifying that the draft decision doesn't include very many disallowances on the basis of prudency. We don't read the draft decision to be disallowing investments on the grounds that they are imprudent. But and the reason in our view, the reason that the draft decision doesn't include those analyses is that what the draft decision is saying is that the company hasn't even provided the minimum quantum of documentation or evidence to allow the authority to conduct that analysis. So the idea is, well, actually, I can talk a little bit about an example if I frame it in regard to the issue of plant and service. The exceptions discuss and Attorney Kimball referenced the issue of the disallowance of some of the interim plant and the apparent confusion about projected plant. Here's how we view the plant and service issue. The company's sorry, I thought I had a question. The company's application is seeking revenues necessary to cover costs. Those costs, as the authority knows, are the depreciation expense and ROE associated with the plant that will be in service in the rate year. So that's the expected total value of plant as of a future point in time. And that future point of time is the midpoint of the rate year. That's the kind of target that we're trying to hit, that the company needs the revenues sufficient to cover the costs associated with whatever that amount is, that amount of value. And that value is made up of two general classes of plant for the sake of the authority's consideration now. Those two classes of plant are the plant that is already in service, the value of that plant that's viewable by the authority at this point in time, minus the interim retirements and applicable depreciation expense. So that plant that exists now, most of that plant existed in the test year, and some of it exists in the interim period because as time rolls on, some plant has rolled into service and the gap between the filing date and the beginning of the proceeding, right? So the authority has to consider that existing plant from a couple of different angles. First is the question of whether that plant even belongs in this rate case at all, which is a baseline question of, does that plant actually exist? Is it being used? And is it useful? And that's the used and useful standard. So there needs to be some verification, some level of assurance to the authority that this is stuff that's real, right? This stuff, these investments have been made, have been rolled out into reality, are part of the grid and are operational. Then there's once that kind of quantum of proof is met, the authority can proceed to the question of whether those investments were prudently incurred. So my read of the draft decision as to existing plant is that it accepts all of the existing plant in the company's application within the test year. I do note that the draft decision is reluctant to accept that. My read of the draft decision is that the evidence that's used to support that existing plant within the test year is questionable, but because all parties seem to accept and no one challenged that plant within the test year exists and is used and useful, the authority accepts that. And that makes sense and is aligned with our recommendation in our brief from the kind of nuts and bolts reality that they've got to get something. There's got to be some level of revenue to support the plant that we know exists, right? Like we're not, if there was nothing, then the suggestion would be that all plant that we know exists now somehow disappeared overnight. So there's got to be something to cover that. Then there's the question of how to treat that interim plant. And as Attorney Kimball referenced, we had a different view on that than where the authority landed. But I want to emphasize that where the authority landed in the draft decision, the thought process to get there was very similar to our thought process. What we did have a different suggestion for how to treat that interim plant, but we did observe that the quantum of evidence used to support that interim plant wasn't enough for us to actually analyze. And I think that's the basis that the draft decision uses as well, in finding that it essentially can identify some portion of interim plant and can verify that plant is used and useful and draws the line there. That's my read of the draft decision. So it's true, as far as anyone knows, there may be existing plant that isn't covered by the draft decision, particularly in that interim period. There's plant that presumably does exist and hasn't been covered by the draft decision. My read on that existing plant is that if the company were to come back and be able to provide sufficient documentation for the authority to assess whether that plant is used and useful and whether those investments were prudent, those haven't been disallowed, that level of plant. So then there's this second, I referenced earlier, there's a second class of plant, and that's projected plant. That's the plant that is not yet used and useful, the plant that has not yet rolled into service. And I I think this is sort of the most important point I want to make here. Is the OCC does not read the draft decision to suggest that the company is no longer allowed to seek revenues to cover projected plants. We don't see this as this decision to suggest we're no longer using a future test year. Instead, our read on it is, well, let me walk that back a little bit and talk about my view of the process for projected plant. Again, what we're trying to do is hit this point. We're trying to throw a dart and hit it in the bullseye of that midpoint in the rate year. And some portion of that value that's going to occur in the midpoint of the rate year, it doesn't exist yet, right? And it's important to keep in mind that that projected plant, when it does roll into service, when it does exist and is used and useful, it still needs to meet the same test. It still needs to be evaluated by the authority for prudency, for use and usefulness, and prudency. But what any company asks from the authority when it's asking for projected plant to be included in a future rate year, it's a harder, in my mind, a harder thing to ask for, a higher bar for the company to meet, because they're asking the authority to agree right now with the company's expectation of what will be in place at some future point, specifically that midpoint of the rate year point. And that the decisions that it will make leading up to that point will have been reasonable and appropriate at that time. That's, in my mind, the test that the authority needs to, that's the lens the authority needs to view projected plant right now. That's not to suggest that you can't have projected plant. In my mind, the way the authority can do that is by making sure that there is sufficient evidence that the company needs to convince you that there's enough in the record for you to agree with the company's projections. It's the basic idea of the company's got a number, it's in their application, their number is the value of their plant and service at that midpoint. They got to that number somehow. There's some basis behind that number. The authority needs to understand how did you get to that number? And it can't just be, well, this is usually the amount that we spend generally. There's got to be some meat behind it. It can't be a bald assertion of fact. It's got to have some hair. Not sure I really like that. That's from a case, as everyone knows, it's sort of a strange saying. But the idea is, you're telling me you're going to build a transformer. Okay, we trust that you know how much transformers cost and you know how to build transformers. And maybe it's okay in the case of something like that to show us, historically, this is what we spent on transformers. We're projecting that this transformer is going to be more expensive because of inflation or because of supply chain issues or because of labor costs rising. Sure, all of that, in my mind, could be possible and could be provable, but it's got to be there. There's got to be some basis for the company to be able to convince the authority that the number it hit makes sense. And that's, in our view, what's missing from this case. But again, to get back to your original question, Commissioner Karen, it's not impossible. And this plant that's the projected plant, particularly the plant that's projected into rate years 2 and 3, according to the company's application, in our view, that's still completely on the table and could still be approved by the authority with a better quantum of evidence, with no harm to the company whatsoever, because we'd be talking about a future that isn't even going to have elapsed by the time this single rate year is over. Just one moment. I just wanted to add again, maybe a little plug for this section of our brief talking about those standards, and maybe a reference again to Commissioner Karen's suggestion that I think all of this could be easier. I want to draw a distinction, though. I don't support the notion that because there isn't a clear document like an SFR that lists exactly the documentation that the company must provide in order to support projected plant, because that document doesn't exist, that the company is somehow prejudiced as a matter of due process, or that the company somehow can't meet its burden because of the lack of that clarity up front. In our view, the SFRs, the standard filing requirements, are really just a basic preliminary procedural minimum filing requirement. It's the same thing in our view as the Superior Court uses in a civil case, that there's some basic requirement. If you want to sue somebody, you have to provide some level of documentation. But that documentation, once you provide that level of documentation, it doesn't mean you've won. It doesn't mean you've convinced the judge that you're right. It means you've provided enough, you put enough information on the table for everybody to have a conversation, for everyone to actually be able to begin evaluating the merits of your case. And after that, you have a discovery process and you build the record. And it's the same, we see the SFRs as very similar. Could the SFRs be improved, or could we have some other, some greater level of clarity for the specificity that the company should expect, or the standards that the company should expect to meet in order to meet its own burden? Sure, that would be helpful. That would be helpful as a matter of administrative efficiency. It would make my job easier, and I'm sure it would make a lot of people in this room's jobs easier. But that's not a legal issue in my mind. Like that's a completely separate issue from the due process arguments and the burden arguments that I've heard from the company.
So you'd like to see a supplemental standard filing requirement, an SSFR?
Yeah, that's a great, yeah, I think that
Okay.
sounds like a great idea.
Hmm.
If we could add another S in there, that would be even better.
Thank you.
Attorney Wheel, a joke about USSR. A joke about USSR. Never mind, I'll ask you later. Okay. Attorney Wheel, what about this suggestion that there's and hopefully I'm not mischaracterizing it, but what about this suggestion that the authority is obligated to provide some kind of notice that it's going to be and maybe this is a point of disagreement where I think you heard Commissioner Karen at the outset talk about the application of existing legal standards more rigorously. So what about this suggestion that there is some kind of notice requirement that the authority is going to be doing its job?
I would frame my understanding of that suggestion similarly to the way you just framed it, Chairman, in that I don't see any difference here. I don't think that there's been any difference in the legal standard that's applicable to the company or any other party in this case. And I say all this knowing the OCC puts on affirmative evidence in these cases too. We're also a part of we incur the exact same scrutiny that the company does. And from our perspective, we don't feel that we need notice because the authority might have a particular interest in the level of detail of something that we're provided. I'm not sure I even understand really what the issue is. I think it kind of gets back to the thing I was talking about before with the SFR is that ultimately the company has the burden of proof. It's not really a complicated concept. The company has got to come here and convince everyone, convince the three commissioners in the case of this proceeding by a preponderance of the evidence, as Attorney Kimball pointed out, that what they say they need is actually what they need. And they should do a really good job at that if they want to get what they want. But exactly how good of a job they need to do, that's on them. I don't understand. I'm not aware of any burden standard that spells out, specific kind of hoops you have to jump through in order to meet that standard of convincing an adjudicator. Ultimately, the only legal standard is that preponderance standard, which is, in my mind, it's a 51%. It just means it's more likely than not. And ultimately, from my point of view, looking at the draft decision and the vast body of evidence in this case, I agree that it's entirely reasonable that PURA has apparently reached the decision in this proceeding that as to a great degree of the evidence that's put forth and as to a great degree of the things the company is asking for, they haven't met the standard. It doesn't appear more likely than not. And again, not to reiterate what we argued in our brief or our short exceptions, this case is riddled with examples. There were so many of them when I was drafting our brief, I just sort of had to start putting them in bullet points because we had already reached 250 pages. But there are many examples of areas in this proceeding where the company simply wasn't able to or refused to provide information when it was asked. There's more than enough evidence in the record here to demonstrate affirmatively that the company simply hasn't exercised a level of due care in even putting on this case that's necessary to be able to convince the authority by that preponderance. I wanted to say one more. This might be a little too specific, but I wanted to say one more area. Well, I wanted to say two more things. I first wanted to address this argument that I see in the exceptions and that Attorney Kimball talked to you about a little bit. The argument about the 5 to 6% effective ROE. My understanding of what the company's doing there is they're pretending that there is some reality in which we're overlaying what's in the draft decision over the company's actually incurred experience at some point in the past, and then projecting that, deciding that that is what is happening in the future, and that's what the draft decision is doing. In other words, my understanding is that they're taking their actual earned return on equity, in this case, in December of 2022, I think Attorney Kimball said, and saying, let's pretend that that the year 2022 is going to replicate itself. We're going to have a mirror image year 2022 in the year 2023, 2024, the applicable rate year in this case. And then we'll apply the draft decision conditions to that. And that's what the draft decision is actually giving us as an allowed ROE. It doesn't make any sense to me as a matter of logic. I mean, it's assuming that kind of everything that impacted the company's business operations in a given year in the past is going to happen again. I presume. I don't understand it. And it subverts the whole process, the whole rate making process we all just laboriously went throughout this case. We had a test year. The test year was tested, examined. The company put, like, the whole premise is that we picked this test year and everything, we're using the test year as sort of a baseline to understand, well, what's going to be similar about this year in the future, and then what's going to be different. And the majority of what's in the company's application is about pro forma adjustments to the test year. It's about showing how they're going to need more than what's in the test year. In fact, the whole rate case is about the incremental revenues they're going to need. The revenues they're receiving now is sort of a baseline. It's sort of, there isn't a lot of focus on that in the case. So given that framework, I'm still just confused about this theory that about the applicable, the 5.6% ROE thing. I can't wrap my head around it. The other point I wanted to make, just a quick one, is about the constitutional standard for the return. I saw in the exceptions, and Attorney Kimball also referenced this notion that the Bluefield case suggests that the standard is that a company in Connecticut has to have an allowed rate of return that's in line with the regulatory agencies and other states' decisions as to what the companies that they regulate are allowed to earn in their return. That's not what Bluefield says. The Bluefield doesn't even talk about the authorized rate of return when it discusses comparability to other businesses engaged in similar levels of risk. So I feel like that's just moving goalposts. It doesn't make a lot of sense to me. In fact, there was testimony in the record in this case. I believe I was cross-examining EOE's cost of capital witness and talked a little bit about whether it makes sense to be comparing authorized rates of returns in other jurisdictions, given the potential for a feedback loop that can happen. Because in my mind, if you look at the historical results of acting under that standard, there's nothing driving the potential for that allowed ROE to move anywhere but up. Because if we're always just saying it can't be any less than anyone around us, then it can always go upward, and that can't be what the Supreme Court meant. So I just wanted to make that point as well. And I think with that, I would just defer to our exceptions and our brief and thank the authority for its very careful analysis of the record and for coming to a entirely rational and sensible decision in this case.
Thank you, Attorney Whale and Consumer Counsel Coleman. Let's keep moving. I think the next folks I see are Attorney Marshall. Deep, please.
Thank you. Thank you to the chairman and to Commissioner Karen for the opportunity to speak today. I will just start with saying that my comments will be very brief. Deep is very aware that there is a lot at stake in this proceeding, and we appreciate those parts of the arguments made here today that are based upon record fact and legal interpretation. While Deep is not taking a specific position on all of the issues raised by the company, as it did not brief all of those issues, we appreciate the expertise of the Office of Consumer Counsel and the hard work that they have invested in this proceeding, and generally agree with all of their positions. We trust that Pura will weigh all of the evidence and arguments and arrive at a decision that equitably balances the risk to the regulated utilities from any disallowed expenditures, with the need to hold the utility accountable to be fully responsive to discovery requests and to adequately support its expenditures to arrive at a decision that is in the best interest of ratepayers. As noted by Consumer Counsel Coleman, our ratepayers are already burdened with some of the highest electric rates in the nation, and they should not be expected to pay their hard-earned money for anything that UI refused or was unable to provide adequate evidence for in this proceeding. Deep specifically supports OCC's recommendation for, as Commissioner Karen has deemed it, an SSFR, to require filing of more specific data supporting the utility's capital plans, and also to file additional data at the time when plant enters service, and to allow for a comparative review of the plan and the plant as built before authorizing the company to recover a return of and on its investments and rates. Such a model, we think, would enhance regulatory certainty and further clarify expectations for the regulated utilities, furthering the opportunity to avoid any unnecessary risk. That concludes our comments for today. We thank you for the opportunity to present in this proceeding.
Thank you, Attorney Marshall. I just have a question or two, if I may. So first, just a general question. Did the department have an opportunity to review the company's exceptions with respect to the English station ROE reduction?
Yes, we did review.
Thank you. And I remember this attorney from the
Yes.
proceeding. I remember your first name is
Brendan Shane.
but
Thank you.
Shane. Okay. Attorney Shane. As you've answered the question that you've had a chance to review the company's exceptions with respect to that ROE reduction. Can you refresh my recollection as to whether the department took a position in the brief or the proceeding as to whether UI is in violation of the partial consent order? Did you take a specific position on that?
The department believes, and the evidence shows, the consent order required full compliance 3 years after its execution. And the testimony in the record shows that full compliance has not been achieved.
Okay. Sorry to be overly pedantic, but is the
So
answer
yes, yes.
Okay. Okay, thank you. So does the department have a position then as to whether it found the company's arguments and written exceptions persuasive as to Pura's jurisdiction or lack thereof to impose an ROE reduction, given that the department feels that the company, or the department believes that the evidence shows that the company is in violation of the PCO?
Sure, there are two things I think that stood out to us in the exceptions. The first is that there are several errors of law. In the legal scheme, the company argues the department should use to seek recourse. For example, the references to 22A6B and 22A6DD are misplaced. Those statutes are not applicable to this matter. The second point I would make, though, is that the department and the authority have concurrent and probably overlapping jurisdiction. The department is ultimately responsible for enforcing compliance with the consent order, but the consent order is a legal obligation on the company. And so Pura, through its merger decision and through this decision, has jurisdiction to determine if the company has discharged those legal obligations in a prudent and efficient manner. And I believe that's what Pura did in its decision, and we would support that analysis.
Thank you. I appreciate that. And I have one more question. I'm not sure if this is more for Attorney Shane or for Attorney Marshall. But the question is, so based on that last response with respect to the merger conditions themselves, does the department take a position on what alternative remedy that would be up to PURA, like in terms of enforcing that condition? If we weren't to enforce that condition through an ROE reduction here, certainly we have the jurisdiction to enforce the condition somehow. Well, let me stop there and ask if you agree with that assessment.
I would say that I've not evaluated the full extent of PURA's jurisdiction, although I assume, I'm willing to accept as a hypothetical, it has the authority to enforce its decisions.
Okay,
But I'm not an expert on the extent of PURA's authority to enforce its decisions.
understood. Attorney Marshall, do you want to opine on?
I think that PURA has the jurisdiction to enforce the conditions that were established in the merger decision. And so the PCO was a condition of that decision. And so I believe that PURA can establish its jurisdiction that way through the merger decision.
Are either of you aware of consequences of not fulfilling a merger condition? Did that merger decision spell out consequences for failing to comport with those conditions?
I'm not aware of that, no.
Thank you. All right, any questions?
Yeah, I had some thoughts on the same issue and obviously noted that the acquisition of UI by Avangrid likely would not have passed without the English station component being part of a partial consent order. And I don't think there's any doubt of that, frankly. But is PURA in fact a party to the partial consent order in any way, shape, or form?
I don't
And
believe.
consequently having responsibilities and or rights and obligations.
So the partial consent order is a final decision of the Commissioner of Energy and Environmental Protection and is therefore a legal obligation. And so I think as with any other legal obligation, the authority can examine whether PURA has, whether the company has discharged that obligation properly. And so whether the company is or is not a party to, whether the authority is or is not a party to the order, I don't think prevents it from evaluating whether the company, which is a party to the order, has discharged its obligations in accordance with the standards that you're tasked with evaluating.
But couldn't DEEP itself call the company to be in breach of the order and look for its own remedy?
Yeah, yes, I believe there's concurrent and overlapping jurisdiction. I believe the department can do that and the authority can act. I think both have the authority to act.
And in the past 4 years, excuse me, has the department begun any proceedings to enforce the partial consent order?
So I want to be a little careful to stick to the record in this matter. There's not an official proceeding,
Okay,
but I would say that the department has been engaged in seeking compliance with the partial consent order.
okay. Appreciate that. And I appreciate you trying not to add any evidence to the record. Thank you.
Thank you.
Okay, thank you, Madam Chairman.
Thank you.
Any further questions?
Thank you, Attorney Marshall. Give me just one moment. I don't want to go too soon. I don't believe so. Thank you very much for addressing our questions.
Thank you.
Thank you. So let's see, the Attorney General, please. Attorney Wright.
Thank you. Is that audible? Thank you very much. Good afternoon, Chairman Gillette and Commissioner Karen. I won't repeat the comments made by the Consumer Counsel, Attorney Wheel, or DEEP's responses to your questions, but I echo all of them. And I'll happy to entertain any questions you may have about them. There's been a lot of hyperbole and overstatement in response to the department's draft decision in this matter from the company. I've never seen so many spontaneous letters from individuals, businesses, employees, as the chairman noticed at the beginning of this proceeding, all of them protesting the authority's failure to provide a bigger rate increase for the utility company. It is simply extraordinary. The spontaneous movement of people joined together with the local utility company to pay righteously higher rates. There's police presence outside of the building. At least it's first for me. Why would all these people do that? And I think that's the question you are asking, Chairman, at the beginning of the proceeding. I think it's because they're frightened. Somebody frightened them. One thing I'm confident about, and that's you and your outstanding staff. I would have cautioned you not to be intimidated by any of these proceedings, the sounds and lights. But I know you, and that you will not be. I think our only advice would be that you should do the right thing, what's right and proper, just and reasonable. Do your best, and then let a court tell you if you're wrong. Everyone at least will know where they stand, and everyone will be better informed for now and in the future. A running theme in UI's exceptions is not just that the draft has errors, but that they've been wronged. On page 1, the exceptions read that the decision appears to be a contrived, purposeful outcome designed with the singular objective of distressing the company because it is a public utility company. And that's just not true. A lot of people hate their utility companies. It's a natural, it's far more than any other industry in the state. But not us, and not any of the people that work with these utility companies. From senior executives on down, these are the most public-minded services and companies in the state. In fact, I agree with very much of the next couple of sentences they write on page 2 of their exceptions, that the provision of distribution service is an awesome responsibility requiring a deep bench of highly skilled and educated employees who look out for customers 24/7. Through pandemic, 100-year storms, this is an awesome company. They're awesome because of their dedicated and professional management, from Mr. Reynolds all the way down the line. But no company is perfect, and I think UI is right that there have been changing standards that are being, and how utility companies are being examined recently. And I think this is, as Consumer Counsel mentioned, a lot due to the transition to performance-based rate making, where a company's financial success is tied to its actual real-time performance. This is supported by the legislature, the governor, the PURA, stakeholders, and the utilities themselves. And the utilities are right that they want to have metrics that reflect what they can control and don't punish them for what they can't. But I think that's what this draft decision does. For example, in the English station, you were assessed 20 basis penalties. There were 5 different penalties. All of those penalties were things totally within the utility's control. But I would like to talk briefly about the English station because it seems to matter in your questions towards DEEP. We recommended that 20 basis point reduction. It's about UI's accountability. Accountability for breaking its promises on remediation. There's no question they broke their word. They're 4 years overdue. Only half the money has been spent. There's no security at the site. They've had 6 different projects managers. And as Deep said today, there's still no plan in sight for completion of the remediation. UI claims and that the AG and Deep offered no evidentiary support for the conclusion that PURA reached, and we respectfully disagree. In a few pages later from that statement, that was on page 79 of their exceptions, they provided fully the transcript cites to UI failed to complete the English station remediation, quote from the draft decision, transcript 3367, lines 14 to 16. That's That's all in their exceptions. You can find that, and I won't read them out. But that's all the evidence you need. And there's evidence to support each of those conclusions that I just read out. Council argued today that the decision has no legal viability, or that the decision is unlawful or irredeemable. Again, I would just say, let a court tell you that. You've taken a very carefully documented, for each of your decisions, they were very carefully documented with cites in the record as to why you made your decisions. The only other comments I'd like to add would be, because you asked about the supplemental standard filing requirements, our office would support any additional standard filing requirements that would be helpful to get the authority the information it needs to make the decision it needs to. That's good for everybody. That's good for the company. The company should be happy for that. The authority should be happy for that. And it will give everybody more confidence that they're getting the information to get the answer right. The last aspects that I wanted to address was the concurrent jurisdiction with Deep and Pura over the approval of UIL being acquired by Iberdrola, and the commitments made therein that were accepted as part of the merger decision. There is concurrent jurisdiction. You issued that decision with one commissioner dissenting, but nonetheless, there's broad plenary authority for the Pura under 1611 to govern all manner of operations of the company. This was specifically integrated into the acceptance of the merger agreement. You still have operational control. The concurrent jurisdiction is not a mystery. It's the same as if sometimes the Attorney General may have concurrent jurisdiction over remedies after the Pura has found things. There was a weird period of time before the legislature fixed a problem in the statutes where Pura appeared to have punishment authority, but not restitution authority. And that has been corrected, but for a while there was concurrent jurisdiction where the Attorney General could on his own work to provide restitution for customers to fill in the gaps. And that's precisely what the situation is parallel to here. You have full Pura jurisdiction over the merger agreement, and you should rely on Deep to certify if and when that property has been properly remediated so that UI can get from underneath this penalty. And UI should embrace that opportunity. I'd be happy to answer any questions if I didn't already.
Thank you, Attorney Wright. I think you contemplated my questions, so I don't have anything further at this time.
Thank you very much.
Okay, looking back. Did the Office of Education Outreach and Enforcement have oral argument? Attorney White, please.
No, ma'am. Our comments would have mirrored much of what OCC said, and so we will be respectful of the time and the time that's running over and defer.
Thank you. Attorney Goodman.
Good afternoon, Chair. CIEC does not have oral arguments at the moment. We'll rely on our post-hearing brief and exceptions, which I think clearly articulated the limited exceptions and requests for clarification that we had.
Thank you. Any question? Can you give me just 1 second? I want to make sure. I think I might have had a clarifying question on one of your written exceptions. I'm just a little out of order here.
Okay.
Just bear with me for 1 second. I'm so sorry. No, I don't. So thank you very much for being here.
Thank you.
Okay, working backwards. Miss anybody over here? Any parties or interveners? Let's see, Attorney Bogan. Followed. Mr. Tom, recognize you from the hearing, sir.
Yeah, good afternoon, Chair Gillette, Commissioner Karen. This is Scott Thompson with Mintz Levin on behalf of NECTA. I was engaged in the hearing as well. It's
Yes,
good
sir.
to see you again.
You too.
And I'll try to be fairly direct on this. NECTA agrees with the proposed decision's treatment of excess accumulated deferred income tax, and also finding that UI had improperly used its parent's company tax data for calculation of the tax factor in the poll attachment rental formula. However, as we put forth in our written exceptions, it appears that the proposed decision errs on the treatment of the appurtenance investment factor. And it appears that maybe it came at it with an erroneous view of or misunderstanding of the FCC's background treatment on this appurtenance factor. Now, you'll recall that just very briefly, the rental formula subtracts from net poll investment the investment in it reduces the net poll investment by the investment in appurtenances. And the FCC had created a rebuttable presumption that factor was 15%. But that has always been a rebuttable presumption. The FCC has repeatedly set forth in cases that we've cited that the rebuttable presumption applies only if neither party comes forward with probative direct evidence on the actual investment. So it goes both ways. In fact, the utility in theory could come forward with evidence saying, in fact, that it thinks the presumption should be lowered. The FCC has also made clear that the presumption can be rebutted using not only full data, but also sample data. So it's talked about statistically valid surveys and samples. In this case, based on its experience with other utilities, NECTA sought discovery of UI's investment in appurtenances. This is not something that is publicly available. It's not broken out in the FERC Form 1. Initially, UI's response was sort of essentially, well, we don't keep it, we don't have it in that format. After some working between us with the parties, UI produced all of its actual investment in appurtenances for 2021. And what it did is it went work order by work order and came up with its full investment in appurtenances for 2021. And I want to make very clear that, and this is all on the record, UI has admitted that this is a representative, they said it was an adequate representative sample for this calculation. And that was in the rates panel rebuttal testimony at 38. It was also in the during the hearing, the transcript at page 543 at lines 20 through 25. UI has also said that the capital expenditures in this sample test year are, quote, representative of current engineering standards and material costs. Again, this was in UI's response to RRU 507, and also in the hearing at transcript 543, line 20 through page 544, line 4. So NECTA has pointed to this data, which leads to an appurtenance factor of 25.11%, as being as fully meeting the FCC standard to rebut the presumption. This is what should now be used, because rather than just using an administratively convenient presumption, we have the actual data. And I point to our expert, Ms. Crafton's rebuttal testimony at page 6, in Exhibit 1, where she calculates this 25.11%. The proposed decision, however, opines that this is, it says, not sufficient as a sole means to justify rebutting the presumption. That is, I would submit, very clearly in conflict with the FCC's orders and decisions that say that you can use just plain survey data. So for example, I'll give you a very quick example. Let's look at a different rebuttable presumption regarding poll height. There are lots and lots of polls. So sometimes what they'll do is the parties will do a survey rather than get the poll height for every single poll the utility owns. They'll use a survey that will then be used to rebut the presumptive poll height. In this case, what we have is all of UI's data from 2021, which it represents is a representative sample that's appropriate for use for the calculation. So we would submit that rebutted the presumption, and that is what should be used. Remarkably, the proposed decision's treatment of the data from UI is internally inconsistent, because at the same time that it says that it was insufficient to rebut the presumption, it also then says, however, that that level of data was sufficient to meet UI's obligations to track and report its data under the FERC accounting rules. We had raised the point that, fundamental to this problem is the first question that we had, which was, give us your property records that show your investment in appurtenances. Under the FERC accounting, so it's at 18 CFR Part 101, the utility is required to be able to furnish, quote, readily full information as to any item included in the account. The proposed decision says, well, the data that was submitted for 2021, quote, let's see if I get this right, was appropriate level of detail that's common in the industry. I would submit that it's impossible for it to be both simultaneously satisfying UI's obligations under its accounting and reporting obligations, but yet not sufficient to rebut the presumption. It's clear under the FCC's rules that the 2021 data is actual data that was sufficient to rebut the presumption and should be used. And it can't, at the same time, though, you can't say that it's insufficient for one thing, but not the other. There are a couple of other, and this really raises a question that we want to focus on, that if this isn't sufficient, it raises the question of what would be. The utility has sole access to this data. If the authority is saying that the amount of data that they produced was sufficient under its record-keeping obligations, but isn't sufficient to rebut the presumption, the utility will never produce the data that's in its control that would potentially rebut the presumption, because it's going to lead to lower poll rates. Three quick other points that I wanted to make sure. The proposed decision says, well, so NECTA's expert had calculated the 25%. UI's witnesses had said that the data supported a 20% factor based on an average of work order by work order. As we explained in our brief, and Ms. Kraft and our expert explained, that's an incorrect approach to go work order by work order, because it inappropriately weights smaller dollar work orders, and the FCC's regulations use total investment. The only other thing I would point out is the proposed decision appears to be under the impression that NECTA was relying heavily on the Eversource appurtenance factor, which is even higher. I wanted to make clear, as Ms. Crafton pointed out, that was the basis for our investigation of what is UIs, because we knew that other utilities have had a trend towards higher appurtenance factors. But once we got that 2021 data from UI, that's been the basis for our position. Were there any specific questions? I know that poll attachments are an exciting topic that
is more fascinating than one might think. So thank you.
Thank you.
Thank you. Attorney Cook?
Good afternoon, Chairman Gillette, Commissioner Karen. I'm actually here on behalf of Crown Castle Fiber LLC and NetSpeed LLC. If allowed, I'll start with Crown Castle.
Please.
Crown Castle appreciates the PURA's examination and analysis of the multitude of issues in its proposed final decision in this proceeding. Crown Castle filed its written exceptions in response to the proposed final decision, so I will limit my remarks to three important items which Crown Castle respectfully requests the authority consider in making its final decision. Specifically, Crown Castle posits that the proposed final decision does not sufficiently meet the principles of rate parity or equity among attachers when considering pole attachment rates. We agree with NECTA that the appropriate appurtenance factor to use in both attachment formulas is 25.11%. And lastly, Crown Castle echoes NECTA's comment that the 6.3% rate of return approved in the proposed final decision should be incorporated into the return component of the carrying charge of both pole attachment rate formulas. As to the issue of rate parity, the proposed nearly 8.3% pole attachment rate disparity between cable attachers and telecom attachers does not meet the FiberTech decision's rate parity requirement, and thus Crown Castle urges the authority to use its discretion and lower the proposed final decision's telecom pole attachment rate to better approach rate parity with the proposed final decision's cable pole attachment rate.
Excuse me, Attorney Cook, when you say to better approach, can you be more specific?
Sure. In the FiberTech decision, the principle of rate parity was established by the authority. And in the last 2016 UI rate case, that the authority deemed a 4.5% differential as within rate approaching rate parity that they approved as between telecom and cable.
Okay, so your argument here is that
The nearly 8.3% disparity does not approach that type of rate parity that was established in the FiberTech decision and in the 2016 UI rate case.
does the 2016 UI rate case suggest that the I'm sorry, I missed the exact number, but the 4.05 or whatever it was is the upper bound of rate parity reasonableness?
It actually speaks to that where it says when the authority decided on those rates, it decided those rates and said this was an opportunity to better align the pole attachment rates between the telecom and cable pole attachers.
Okay, but it doesn't just, do you have it sounds like you might be reading from the decision. Can you point me to a specific page, please? Or does it not have a page number on it?
I have it in my briefcase.
It's okay. I can find it. I thought you just had it there. Okay, thank you. Please proceed.
Thank you. UI's current pole attachment rates approved by the authority in UI's 2016 rate case reflect a small rate differential of 4.5%, which is consistent with the FiberTech decision's rate parity requirement. The proposed nearly 8.3% differential would be nearly double the current rate differential. In establishing the principles of rate parity and equity among attachers in the FiberTech decision, the authority articulated several reasons why it was revising the telecom pole attachment rate downward. Those reasons were abandoned in the proposed final decision, which instead relies solely on the FCC formulas. If those formulas are left untouched, an uneven and unfair playing field will be set as between cable and telecom competitors offering essentially the same broadband services. Specifically, a telecom pole attachment rate nearly 8.3% higher than the proposed cable rate will negatively impact telecom providers' ability to deploy additional advanced fiber facilities in Connecticut by making telecom pole attachment fees significantly more costly, especially when compared to the cable provider's ability to deploy the same type of fiber facilities while paying a nearly 8.3% lower pole attachment rate.
Attorney Cook, apologies to interrupt again, but so just a second ago, I think I heard you say that the draft decision relies on FCC formulas and presumably FCC associated precedent that established those formulas. And that I think I heard your position to be that that is contrary to the authority's FiberTech decision. And are you going to opine on which of those is controlling here, given that we have an FCC?
Sure, because what I think the FiberTech decision did and what the 2016 UI rate case reinforced was the notion of applying the FCC formulas for telecom and cable, but then looking at rate parity and making sure that those results were approached parity with one another. I think that's what the fiber tech decision stands for. And the UI 2016 rate case reinforced that when it talked about the authority taking advantage of that opportunity to better align the rates.
Thank you.
The 8.3%, the nearly 8.3% disparity runs counter to the public interest in that it gives one class of facility-based competitors an unjust advantage and discourages the deployment of advanced broadband services in Connecticut, thereby limiting the availability of advanced broadband services and driving prices of advanced broadband services higher in Connecticut. This runs counter to the importance the authority placed on adopting policies in the public interest and on facilitating more rapid deployment of advanced services in Connecticut in the fiber tech decision. Additionally, a telecom rate more in parity with the cable rate would, according to the fiber tech decision, be reasonable and compensatory and not harm pole owners economically, as it will continue to provide pole owners sufficient incentives to continue to invest in their infrastructure. This would align with the authority's third reason to revise telecom rates provided in the fiber tech decision, namely that it produces efficient pricing signals for an infrastructure investment and the deployment of advanced services. Crown Castle would be incentivized to make additional investments in its network, knowing it was on an even regulatory and competitive playing field. Lastly, as the fiber tech decision determined, pole owners do not incur more recurring costs to accommodate telecommunications attachers as compared to cable attachers. And as a result, a telecom rate in parity with the cable rate would be fair, reasonable, and non-discriminatory. The proposed final decision abandons the very principle that was established in the fiber tech decision, namely the practical difference between a cable provider and a telecommunications provider is increasingly a distinction without a difference, and charging all providers the same or substantially the same pole rental rates to offer an array of different services makes sense for economic reasons and for reasons of equity among attachers. In choosing to assert its own regulatory authority over pole attachments in Connecticut, the authority has the discretion to incorporate these principles of equity and fairness and does not have to only utilize the FCC approved formulas, especially if they lead to an unfair and anti-competitive result. In fact, as we discussed already, the 2016 UI rate case was used as an opportunity to better align the pole attachment rates between the telecom and cable pole attachers when the authority lowered the final rate from the UI proposed rate of $25.52 per pole per year to $14.96 per pole per year. In the interest of furthering federal and state goals to speed the deployment of advanced services and promote infrastructure development, in the interest of setting an even and fair regulatory playing field, and finally, in order to comport with the principles of rate parity and equity among attachers established in the fiber tech decision, the authority should exercise its discretion and bring telecom pole attachments rates into parity with cable pole attachment rates. My last 2 points are regarding the telecom and cable pole attachment rate formulas themselves. Crown Castle agrees with NECTA that the FCC's 15% appurtenance factor is a presumption which can be rebutted, and that based on ample sufficient data provided by UI in this proceeding, the appurtenance factor should be adjusted to 25.11% in both the telecom and cable pole attachment rate formulas. Finally, Crown Castle also agrees with NECTA that the proposed final decision's rate of return of 6.3% should be applied in the return component of the carrying charge portion of both the telecom and cable pole attachment rate formulas. Thank you. take any questions and
I have no questions.
Questions?
Very educational. Very
Sir?
educational.
thank you. As pole attachment issues are, they're interesting, as Mr. Thompson alluded to. So now I'll speak on behalf of NetSpeed LLC. NetSpeed LLC likewise appreciates the authority's time, diligence, and attention paid to the many topics raised in this proceeding. Similarly, GoNetspeed filed its written exceptions in response to the proposed final decision. So I'll be very brief on just a few remarks. First, regarding the calculation of new pole attachment rate formulas, GoNetspeed shares the concern expressed by Crown Castle and by NECTA, namely that sufficient evidence was placed on the record to rebut the FCC presumption of a 15% appurtenance factor. GoNetspeed also supports and joins Crown Castle and NECTA in requesting that the 6.3% rate of return approved in the proposed final decision be incorporated into the carrying charges of both the telecom and cable pole attachment rates. Lastly, GoNetspeed asks the authority to include in its final decision confirmation that UI is limited to charging no more than $58.71 per pole in incremental charges on top of any one-time application fee and per pole survey fee to process pole attachment applications. In the proposed final decision, the authority fixes the projected number of pole requests, specifically 10,500 per year, upon which expected pole attachment process revenues and costs can be calculated for each of the rate years. Based on those numbers, the authority determined UI would incur a deficit of $616,500 per rate year. $616,500 divided by 10,500 pole requests per year works out to $58.71 per pole in incremental costs to cover the determined deficit. Now established by the authority from record evidence, these figures cannot be modified until the next UI rate case proceeding is issued a final decision. As a result, the authority should confirm in the final decision that per pole incremental charges to cover pole attachment application processing costs must be capped at $58.71 per pole. The authority should also make it clear that a portion of or the full incremental charge can only be charged to an attacher applicant if UI is able to show it is receiving 10,500 pole attachment requests per year, or that it is currently engaging the additional 8 full-time equivalents and 1.282 million in external contractors for the pole attachment application process. As a result, GoNetspeed requests the authority include orders in its final decision requiring UI to report on the actual incremental charges per application UI passes through to attacher applicants, and whether UI is presently engaging the 8 additional FTEs and or the 1.282 million in external contractors for pole attachment application processing. GoNetspeed appreciates the opportunity to discuss these important issues with you today. Thank you.
Thank you. Thank you, Attorney Cook.
Thank you.
Questions? I believe that's everyone, which means that we're turning to our rebuttal round. Sorry, Attorney Attorney Bogan, are you approaching? I missed. Oh, okay. Please. Okay. In that case, we are going to transition into the rebuttal round. We are past the amount of time we had set aside for this, so that I would ask that parties in the rebuttal round will go in the same order. I would ask that you please keep your remarks to the point. And we are specifically on the rebuttal round looking for any responses to oral arguments made by other parties, and the bench may have questions based on arguments from other parties too. So with that, I would ask invite Attorney Venora back up, or Attorney Kimball, excuse me.
Mr. Benora will address English Station. I will address a few other points.
Okay, please.
I first wanted to say that we really appreciate the comments of both OCC and the AG. And I think there's a ton in there that the company would actually agree with from a regulatory principle, regulatory practitioner perspective. I think the misunderstanding, I have three, and I'll keep it quick, and appreciate your latitude. 3 issues that are important. And I think this is a little bit of the misunderstanding. Do you smell fear? You do. There is fear, but that fear is not for the reason that you think. It's not because Pure is changing things. It's not because Pure is putting more stringent standards. I know utilities. I know them better than they know themselves. They do lots of good things. They do things not so well. But what they do really good is follow standards. You give a utility a standard, they'll follow it. So what makes it very difficult is when we're in the middle of a proceeding and things start changing, because it's hard to retrench and bring in information that never had to be provided before. So, and I think the real fear here, and it is real, it is not hyperbole. And frankly, I feel a little bit patronizing but I know it's meant in a healthy way, but that this is hyperbole. It's not. I think Mr. Reynolds spoke and he said, if this ever came out like this, the company would be paralyzed. So let me put some words behind that instead of hyperbole. Let me explain why that is. When I have a company that comes in and wants to go for a rate case, it's because they've had a rate case in the past. Rates are set like in a math equation, as we all know. There's a rate of return and there's expenses. And the rates that go into effect, let's just say they're $100. They encompass an allowance for the return, an allowance for capital structure, allowance for expenses. And so a company, when they go in for a rate, but that return is not guaranteed. It's just a bogey to build the rate. And so just like Attorney Wheel said, there's something all completely different going on outside. So the company isn't guaranteed a return. It's like they have just gotten $100 allowance. They got to make that work. And so normally when a company goes into a rate case, maybe their authorized return, let's just say it's 9%. They might decide to go in my experience, like 7.7 or 8%. They decide they don't have an opportunity. They can't get there anymore because their costs are rising. And as costs are rising, the return is going down. So when we think about the constitutional standard, it's 2 parts: the opportunity for a fair and reasonable return and recovery of prudently incurred expenses. If you don't get recovery of expenses and capital costs, you can never get to the return that is factored into the rate equation. So normally when I would take any client, and I've done, I think in my career, I was trying to estimate over there, maybe 50 rate cases. The client comes, they're in the range of 7 or 8%, they're under earning, they come in, they ask for the 91. I think, Chairman, we talked about like a zone of reasonableness. They come in and they make their case that this is what we think are the sufficient revenues. But this gets figured out in the proceeding. Well, if we took a OCC's position on brief of something along a $49 million increase with some capital, not all of it, and I think Attorney Will did a great job of explaining where they were on that. Let's say in reality, that utility is making 7 or 8%, they get a $50 million rate increase. That's going to then give them the reasonable opportunity to earn that return, whatever it is that has been baked into rates, because they've gotten not only the return in that equation, but they've gotten the expenses. And I think Attorney Will said, well, they get post-test year adjustments and they get these things. Well, if your UI, and I think this is where the fear is coming from of how this is going to paralyze the company if you ever come out like this, because as it stands, it is confiscatory. I don't know how to explain to you you can't have a company come in and get zero. That's confiscation. Why? Let's look at the math of it. If you have a utility come in as UI did, and their actual return is very lower, they're actually earning in the range, let's talk hypothetically, 6%. So when you only get a $2 million increase, you don't have a reasonable opportunity to earn the authorized return. The authorized return could be, 8.8, 8.7, that's what the authority has done. But if you gave expenses and capital cost recovery, you had met the standard, a reasonable opportunity to earn that, because the expenses that the utility is carrying are covered. But when you have a decision that comes out and you have a utility earning so far under what is a reasonable return, even in PURA's new vision, they're earning so far under that, and then give them 2 million. There's no opportunity in the rate. They only get revenue out of rates. They don't get it anywhere else. They don't get revenue from anywhere else. So if they come in at 5 or 6%, which is already well below what a reasonable return is under constitutional standard, and you give them 2 million, then the return you've actually given them is 5 or 6%. And that's what we're trying to explain. So the fear that you are feeling from the company and its employees is very real. They're under earning, their costs are rising so much. I know I hear all this bit about earnings and profit. Their costs, like everybody else's, is rising up. And as costs go up, their return goes down. And so they have to come and try to get the revenue to cover operations. So the fear you're feeling is, what is Mr. Reynolds supposed to do the day after? And a draft decision comes out. There's so many things wrong with it that even I literally get overwhelmed even reading it. Like, how will this ever get fixed? And I look at these, and I know these utilities, and what are they going to do the day they come out with a decision? And effectively, you've rendered them to a 5% return, which is we can argue about what is the right return, but that's 300 or 400 basis points below a reasonable return. And I agree with Attorney Will. I agree that we can differ. There's range of what is commensurate ROE, but the PURA has to end up with a rate equation that gives the utility enough revenue to try to make that return. And where I would normally never go into a rate case and be worried about what the utility's actual rate of return is. They filed the rate case because they are under earning. They've put together the costs that they think they need to get up to a reasonable range. You're only hearing about it here because everything is stripped out. You can't lower a return, add penalties, and take away all expenses. And what you're effectively doing is then issuing an order that says you, the utility, will make 5%. So I think even though PURA may be changing its viewpoint on ROE, I hope I'm right that you're not changing it to 5%, because that would not fly. And then the way the court, and I'm talking to you about the way it'll be presented at court, when it goes, if this isn't changed or where it's going in Aquarion, you show the court, once you set rates that effectively have a 5% rate of return in it, every asset that's underneath there in the rate base is earning that 5%. So that is where the confiscation comes from, because the utility has put that investment in and they should be getting a return that's reasonable. It's a range, but it's not 5%. So the problem with this, the fear you're feeling is, what is Mr. Reynolds going to do the day after a decision like this comes out? And he's got no money. He's got no money. Is he going to fire people or not do, what he needs to do? Maybe, because if there's no rules, if PURA is not following the legal framework to set just and reasonable rates. If I heard a little while ago, regulatory compact. It's a compact. It's two ways. PURA has to give the constitutional standard of fair and an opportunity for a fair and reasonable return and recovery of prudently incurred expenses. And then the utility has to meet its service obligation. It's a compact. And I am saying this decision where you have basically a zero increase, and even if it increased to like 20. So that is why we're trying to give you the extra evidence, because this won't even be enough to cover debt payments. Like, so we haven't considered what the impact of the decision is actually on the utility's health. So yeah, people are scared. It's not hyperbole. How are they going to take care of customers at this level? So you can make changes. I mean, honestly, I feel like in my view of the companies in Connecticut, and maybe we just don't get enough chance to talk about it, but they would be reasonable partners in this change that we're trying to occur, and I think they want to be, but it goes way too far. It's too many things. You can hit one thing, you can't hit 40 things, because that's what makes it confiscatory. And this order, if it doesn't get fixed, the capital, the penalties, I get it, you want to penalize, but, and you talking about PBR, you've already penalized the company. There's no PBR on these rates. They're not just and reasonable. PBR has to sit on just and reasonable rates. So I think I just wanted to go through the math. That's why we're trying to show you the math. That's why we filed the additional information for you to consider to try to help you figure out how to get this back on track. It's because the company is expenses and investment are pushing the return down. They got to get more revenues. So I'll leave that, but that is related to another question, another thing I just wanted to bring up, which is, for instance, ESM. I know there's some changes made in the ESM, and I've seen it on other cases, and there's some things that are fine with what, whatever you propose, but one thing that it's not, and it relates to what I just said, you cannot, and this will go to court, and I feel very confident we will win, but we don't want to go to court. We'd rather be working on clean energy future or anything else besides going to court. So I offer you this on ESM. Just like I just talked to you about, if we have a rate making proceeding, it used to be that PURA would disallow 50% of incentive comp. Now, that always bothered me. This is employee compensation. Why is it getting to, I think we can beat this at court. No utility wants to appeal a rate order unless it's unreasonable. So that's why if it stays in the reasonable range of when you do the math and look at what the company's actually earning, they have a reasonable opportunity to earn the set return. They won't appeal everything. They'll live with those decisions. The utilities in Connecticut have lived with the decision for 50% incentive comp. Here, 100%. And why? Not on some finding of prudence, not even on a finding of you didn't prove prudence, but on a finding that you didn't prove a benefit to customers. But under 1619 EA4, it says you get to recover your operating expense, and then you have to prove you're prudent. Well, if it's an operating expense, then the prudence review has to be as the company's decision about paying employees. Is it a prudent decision? Nowhere does it enter into, oh, you didn't prove a benefit to customers. And there's probably 5 or 6 different expenses where the end result, rate case expense, I'm just trying to think off the top of my head, probably 5 expenses where it says you didn't prove, maybe is there conservation expense and it says you didn't prove impact. And so the problem is that's not part of the prudence standard. If it's an operating expense, the law in Connecticut already says, and constitutional law, if it's an operating expense, it's part of how you run the business. to serve customers. You don't have to prove some separate benefit to customers. The benefit is they're getting electricity and it's part of electricity. So I would just ask you to think about this when you go back, because there's about $14 million of expenses that were taken out. So when Attorney Wheel says, hey, don't worry about what's actually going on because they're getting post-test year adjustments and they're getting this other stuff, they're not. They're all disallowed. So I will leave that with you. So then you get to the ESM and you want to say, okay, the ESM is now measuring earnings. Well, earnings are depressed anywhere you've got disallowed expenses because you can't earn your return when you've got disallowed expenses because you're still carrying them, you're still paying them. So now we get to the ESM, you've already, instead of $100, let's say the company got $80. Now you come to the ESM and you say, no, you can't include these expenses in the ESM. So that will be totally appealable because you've already taken that expense out of rates. It's already affecting your ability. So what if you're so efficient that you overcome and get your earnings back up there, even though these expenses are disallowed? Now Pura is going to come along and say, when you calculate earnings, you can't count disallowed expenses that you're incurring but are not in rates. So that's like a double do. That's going to be appealable. That's going to be overturnable because that is a confiscation. You're taking earnings of the company, even though the expense is not in rates. So I would just, and that all goes back to, we only have to be sensitive about what a company is actually earning when we're not giving a reasonable increase for them to do their business. And this is why of the hyperbole, as I'm trying to say to you, it panics me as well, how bad this decision is, not even for my clients, but for Connecticut. I work all around New England. Rhode Island is half the per capita wealth of this state. They have so much more ahead of Connecticut on clean energy stuff, on capital investment. And so it makes Connecticut look like a tiny timer. So I just also worry about the whole overall effect of where this is going, because you know why? It's going to take a long time to get it back if it sinks. So thank you for listening. I have one other issue that I'd like to talk to you about very quickly. Capital plant evidence. It is always a problem in every state. I think, Chairman, you said, should I be feeling bad because I'm doing my job because I'm holding them to a higher standard? No, absolutely not. You hold these companies to a high standard, the next rate case, they will come in and they will meet your standard because it's transparent, it's visible. The problem with capital projects is Pura accepted the level of proof that was produced in this case for years and years and years. And when you get inside a rate case, it's very difficult to rebuild capital project documentation or whatever it is that Pura might be looking for. There's probably 3 different information systems that house the information. There's hundreds, if not thousands of projects. So without that standard set ahead of time, you can't bring all that documentation into the proceeding. And so when you look at the preponderance evidence, you look at what's actually in, the company did in fact have meaning 51% of the evidence showed that they had those prudent investments and that they needed to have that in rates. So I would totally support, the company would totally support, I think all companies would support if we could come up with some type of collaboration to identify what is it that needs to be filed for capital project documentation. The order says invoices. There's no way anybody's producing capital project invoices during a rate case or even a year before a rate case. There's thousands of invoices. So all this talk about how the company didn't do what it was supposed to do, this is what was Connecticut sufficed for evidence for all this time. If you want to change what suffices, do it. But let's set it up so everybody knows what it's going to be. So when they prepare the case, they can give you what you're looking for, because there's a lot of different things that could be submitted. In New Hampshire, I know the companies up there went through a process with the commission to identify what project documentation they wanted. In Rhode Island, that process has happened. Massachusetts has had a standard for over 20 years as to what exactly has to be filed in a rate case. So I really suggest that this is a process, because it is ultimately hurting customers to come into a rate case with all the work that's been done and then say it didn't suffice. And one last thing, it does hurt the utility, because why? These plant is depreciating. So it's just not good enough to say, oh, it's not disallowed, you can bring it back in later. Today, it's worth $100. Tomorrow, it's worth $50. That in itself is confiscating utility property. So we just need to understand what the real issue is here. Okay?
Okay,
All right, I'm going to let my colleague just talk quickly about English Station.
okay, Attorney Venora, and
Yeah,
quickly.
thank you. Yeah, I'm going to just go through this quickly to respond to some of the points we heard from the attorneys from DEEP and from the Attorney General. Commissioner Karen, one of your questions to the DEEP attorney asked about, he asked him, I think, to report on, maybe how it's been going on the consent order. And I think he said, I want to be careful to stick to the record, which I think is a proper response. And that really gets to the heart of the problem on English Station, is that there is no record here. Because it was raised for the first time on brief by the Attorney General and DEEP, there was nothing developed in the record. There was some, I think I counted, there's might be like a handful of discovery responses that ask some, a few questions. OCC asked a question where we produced a copy of the consent order, but other than that, there's never been a case put on. So you have a copy of the consent order. You don't have any evidence in the record as to what constitutes reasonable performance under the consent order. You don't have any evidence about what decisions were made and have been made along the timeline so that you could actually assess prudence. What we have in the decision is just a hindsight. It's kind of it looks at the fact that the timeline has been extended and just extrapolates from that must be indicative of prudence. There's not, there's no basis to reach that conclusion. There's, there's other factors that were never explored and could not have, and because of the way that the issue was raised.
Attorney Venora, I just want to make sure that we sat there the same hearing. Did we, my recollection is that we had at least half a day of testimony and cross-examination regarding the discovery questions and the company's positions on English Station. So I'm not sure that I understand the points that you're just.
Sure. I don't recall it being that long, but it was a long 13 or so days. So there's three items, there's three facts that you talk about in the draft decision. Fact number one was UI has failed to complete the English Station remediation nearly 7 years after executing the consent order and several years past the agreed upon date. So that's a fact, but you don't look at any of the other information that might explain why that's the case. There was no information. So DEEP is the primary enforcer under the consent order. They didn't put any information into the record as to why or what steps they've taken. So the record's completely devoid of that in terms of to be able to assess what are all the factors and the reasons for that timeline.
But the PCO, if I recall correctly, is in the record, correct?
It is.
And I don't recall the PCO having any, I don't know what you call them here, conditions that excuse non-performance. Certainly the authority's decision in, what was that, docket 150738? I did not read that decision to have any conditions that would excuse non-performance of a merger condition. Is the company's position to the contrary?
Well, I think the question is who, I have a comment on the merger condition, but the jurisdiction here lies with DEEP. This is the jurisdiction under the consent order to enforce the requirements under the consent order it lies with DEEP. It doesn't lie with PURA.
So it's the company's position that the authority does not have the jurisdiction to enforce a condition that was agreed to in a settlement agreement by the company as a condition of approving the merger.
That's not what I said. So the merger condition said UI has signed a consent order. I'm paraphrasing that when approved by the commissioner of DEEP and subject to closing of the merger and other terms and conditions in the consent order requires UI to investigate and remediate certain environmental conditions within the perimeter of the English Station site. And then it goes on to talk about the $30 million amount. There's no language in that consent order that gave PURA jurisdiction to oversee the actions under the consent order or to oversee the investigation or remediation. It's not in those words.
So what is, I mean, I wasn't here for that decision, although I think Commissioner Karen just a few moments ago alluded to the remediation of English Station being a huge factor in terms of the authority approving the merger. So if I've already mischaracterized your position once, let me try again. I think what are you suggesting the nuance between our positions now is that the authority's jurisdiction was limited to ensuring that you signed the consent order, not that you faithfully implemented it?
I'm just going by the words of the consent order, that it acknowledged that the company had signed it, that it's subject to DEEP approval and oversight and enforcement. That was the limit. So that it becomes, it's part of the settlement agreement in the merger. And that's included as one of the reasons for approval. But I don't think it could be, I don't think you can convey jurisdiction on an administrative agency in that manner. I mean, this is it's within the scope of DEEP's authority. So that's the way I look at that.
I appreciate that. I think where I'm really struggling is just to extrapolate that position to other mergers that I've overseen here and elsewhere. By that, I'm struggling with what the company's position would be for the enforcement of any merger condition that is in and of itself, perhaps not explicitly within our jurisdiction. So by that, in merger agreements I've seen before, a company may commit to keeping its unregulated parent company in the state, or may commit to not having any involuntary termination of certain companies. So where I'm struggling with accepting the position that you're putting forward here is, by extension, that would mean that the authority has no jurisdiction to see the fulfillment of other conditions that it accepts as a precondition of approving the merger, simply because they are not within its normal administrative jurisdiction. And simply put, I feel like that's an absurd result. So I'm trying to square your interpretation here with that, to me, logical extrapolation.
Yeah, I think it's hard when you try to extrapolate from the specific language of this specific provision in the merger settlement, because we have a specific statute that gives DEEP the enforcement jurisdiction, and the consent order is between it's approved by DEEP. I think I mean, I can't give you an overarching statement about every merger condition and how that would work. I'm just talking specifically about this one. And so I think that's the difference here. And, so
does the authority have any remedy if English Station is never remediated? If the company does not complete its PCO, which the authority accepted as a condition of the merger, what is the authority's remedy?
Well, I mean, I think it goes back to when the case was first filed. I think it relates to whether ratepayers are bearing any costs here. And that, because that's where it comes down to. And the company demonstrated that there are no costs for English station in rates. So it's not borne by customers. So I think that's where that, and that's why the case was framed the way it was, just to make that, to provide that information, because English station has not been in rates for a long time. I'm drawing a blank on the year, but it's, 10, 20 years. And so I think that's where it comes, Pura is the economic regulator. And so this is a matter of enforcement, that lies with a different agency, not here.
Okay, I appreciate that. Let me try to rephrase my question because I think I'm asking something, or I'm trying to ask something different. A condition of the merger was the faithful completion of this PCO. So if you're drawing the distinction that you don't think Pura has the jurisdiction to enforce the PCO, what is the authority's remedy to the fact that a merger condition has not been fulfilled? Is it to unwind the merger? Because that's about the only other remedy that I've seen included in other merger agreements.
There's no evidence in the record that a merger condition has not been fulfilled. There's no evidence of that.
There's no evidence that the company's position is that there's no evidence that English station has not been remediated.
There's no evidence that the consent order has not been followed. And so and that gets to my first point. The record was never developed. You have on its face, you have the timeline in the consent order, but you don't have any other record to make a determination other than in hindsight, whether or not the company has acted reasonably along that timeline and the factors that have affected that timeline. That's the first point. The second point you rely on is you say the company has, quote, cycled through 6 project managers. The affirmative evidence in the case by Mr. Mullen was that has had no impact on the company's progress and activities at English Station. But it's just cited. It's a fact. The company doesn't dispute the fact that there's been multiple project managers, but it has not affected the remediation. The third point, and this is where Attorney Wright made a huge overstatement. He said that there's no site security. That's completely wrong. The only evidence in the case was a question to Mr. Mullen, was he aware of there being graffiti on a fence? And I think he said he didn't know when it had been there. That's not a breach of site security. We don't know whether that's a violation of the consent order. So it's a completely, those are the only 3 facts in the record. That's what's relied upon in the draft decision.
I have no further questions.
Thank you.
Thank you, Attorney Menora. See, Office of Consumer Counsel, please.
Thank you. I'll try to make it quick on this late Friday. Just had a couple of things to respond to. There's the issue of the question of the benefit to customers that Attorney Kimball raised. I think I heard Attorney Kimball argue that that prudency is the only kind of evaluation that the authority should be looking at costs through, and that essentially as long as the company's incurring operational costs, they got to recover them. That's not true. That's not what 1619E or 1619A say. But both of those statutes provide guidance that Pura has to ensure that rates are structured in a way that demonstrate. 1619E says a clear public need. So to me, a clear public need means that the company has to demonstrate that its costs are incurred as to what the company needs. It needs to be connected to its provision of service. 1619A talks about the standard of rates not being in excess of public necessity or convenience. So again, neither of those things has anything to do with prudency, whether the financial decisions in incurring the costs were reasonable. That is a standard the authority has to conduct. But there's all kinds of statutory standards in the statutory framework that PURA also needs to consider when evaluating a rate application. So every exclusion in the draft decision that stems from the lack of evidence showing a benefit to customers is fully supported by those two statutory provisions in my mind. There's also some comments about constitutional confiscation, and I think I understand the argument to mean essentially you just got to give a utility enough money to operate, otherwise it's unconstitutional. And I don't mean to be overstating the argument, but that's my understanding that there's got to be like some that if the utility walks away with zero revenue, that's per se confiscatory. And that just can't be the case. Like when we're talking about confiscation, we're talking about the takings clause. The idea is the company needs to be provided just compensation for the taking of its property for public use. But there is no takings clause scenario that I'm aware of where the person who's or entity that's having their property taken can just not provide enough information for the taker to analyze what the just compensation should be. And that's the situation we're talking about. The PURA just needs to understand what PURA needs to understand, have enough information to analyze the actual values that are at issue here. That's the constitutional question: is what is this stuff worth? What exactly is being taken from the company for public use, and what is that value? And how can PURA determine that without a minimum quantum of evidence? That's the question. So I disagree with the notion that there is any per se confiscation. The utilities gotta come to the plate. The utility, that's why they have the burden. They're the ones coming here asking for a rate increase. They've got to come to the table and justify their ask. Not to repeat what I said before, but they have to convince you. It's not that there's no way to interpret my understanding of Attorney Kimball's argument that doesn't result in no burden being on the utility whatsoever. And that can't be the case because, as the authority knows, the burden's in statute here in Connecticut. I also just want to respond briefly to the colloquy just now about English Station. Maybe what's hanging the company up here is I heard Attorney Venora repeatedly talk about the authority and not having the PURA not having the authority to enforce the consent order. I don't think that's what the draft decision is doing. I don't think the draft decision is enforcing the consent order. In my mind, what happened was there was a merger. A condition of the merger, as ordered by PURA, was for the company to adhere to the consent order. Then there's the question of, did the company violate that condition? That's what's being enforced here. And then how do you measure whether that condition has been violated? Well, you look at the consent order, it's in the record, and then you look at the other evidence in the record. And if PURA, using its legal levels of deference as the fact finder, looks at the facts that have been entered into the record and compares them to its view of what the consent order requires, it can determine this is a violation of the order we issued because these facts show that the consent order is not being adhered to. This question of whether it's being prudently adhered to, I don't understand that at all. Prudency is the evaluation of a company's investments. As Attorney Venora noted, this isn't a question of investment. It's not a ratepayer question at all. This isn't an area for prudency. This is just like any other violation of a regulator's order. The question is just, did they violate it or not? Did they do what they were supposed to do or not? And if the answer is no, then they can be penalized for it. And that's what I see the draft decision doing. And just one last point, I think the chairman already touched on this, I think, with the questioning, but the fact that there isn't necessarily a ratepayer connection to the enforcement of the consent order is irrelevant in my mind. This is, as the chairman alluded to, these conditions happen all the time. The company didn't object to being subject to this condition of the merger, and the fact that it involves some action that the authority couldn't otherwise enforce, that makes no difference to me. The authority had the legal authority to issue that order, and again, the question is, did the company violate the order or not? That's it. That's all I have. If there are any questions from the bench.
I just have a quick one. Because you mentioned it in your first time around, that the company made an assertion, rather bald assertion, and it wasn't enough hair on it. And what I heard Attorney Venora say is kind of the same thing, that yes, it hasn't been remediated. Nobody asked why it hasn't been remediated. So it's a bald assertion, but not very much hair on it. Am I getting the oranges right, or is there an apple in there?
Well, I think maybe the difference there is the issue of the burden. Who has the burden to demonstrate that the company hasn't violated the consent order? I think the issue of the baldness in the hair is directly related to the company's duty to convince you of what it wants to spend. Or sorry, how much it wants to increase rates. I think the question, but I think the duty also, I think the burden here is a little murkier because it's just the question of who has the burden of the authority keeping track of ensuring that the people who are subject to its jurisdiction in the form of its duly rendered order are following that order or not. And I think the issue of the quantum of evidence, the hair and the baldness, that is something sorry, we need to change that. That is something the authority should evaluate. I think that as the trier of fact, the authority can look at the record and determine whether there was enough offered to justify a finding that the consent order is being followed or not. I will supplement to say my recollection is that the vast majority of Attorney Bidra's cross-examination pertained to English Station. My recollection, I think, aligns with the chairman's, that there was a substantial amount of testimony that I particularly remember is a substantial amount of testimony pertaining to the security measures. I think the record speaks for itself, but I think there were several questions regarding the graffiti, the amount of time that the company was unaware that someone had accessed the site and hadn't apparently done anything about it. We also issued more than one interrogatory pertaining to English Station. Our intent was specifically to seek information pertaining to whether the company had been adhering to the condition of the merger. There were several other parties who also sought information during the hearings and through interrogatories. So I would disagree, but I would say the record speaks for itself.
So one last point. Is this really the venue for this particular issue? If presuming that the authority does have the ability to enforce the conditions of the original merger, that maybe this isn't the venue for it, but perhaps in a different proceeding? Or is this the proper proceeding to do this?
I think this is the proper proceeding because if the penalty is if the authority has determined that the proper penalty is a reduction to the return on equity, that can only happen in a distribution rate case. Thank you.
Thank you. Attorney Marshall or Attorney Shane? And somebody's left their water up here if you want to grab it while we're switching over. Attorney Venora.
Thank you. We just have very short comments, no particular issues on rebuttal, but we just would like to concur with many of the statements that OCC made related to English Station. We agree that the company made this an issue by improperly including expenses associated with English Station in this case. And so when the evidence demonstrated that UI had not met its obligation with respect to the remediation of English Station, it was at that point that it became their burden to demonstrate any reason that it had failed to do so. So what's happening here is not that Pura is enforcing the partial consent order. Here, Pura is properly enforcing the conditions of the merger, which we believe is well within its authority. Which relied on the consent order. It was partial justification for the merger. And so we believe that's fully within Pura's jurisdiction. Thank you. Those are my comments. If you have no questions, thank you.
Thank you. No questions. Thank you. Attorney Wright.
Promise I'll be brief. I did want to point out the page numbers on page 82 and 83 of the company's written exceptions, which describe the site testimony given during the hearing. I think it was about March 21st, that speaks about the failures at English stations. There is documentation of it. In fact, specifically with respect to site security, Steve Mullen, UI's remediation director for English Station, testified, I think on 3/21, at pages 3350 and 3360 that graffiti was not in the picture of the site 2 years earlier. And it happened within the past year or two. Either way, that's the time that UI has been in charge of site security under the partial consent order that was entered in 2016. It occurred during UI's tenure of responsibility for site security and fails to satisfy the section B3 of the PCO. It admits that it's supposed to keep site security at the same level as when it took over control of the site, and it has not. The vandalism was not there prior. It occurred while UI had sole control over the site, and the inference can be drawn that the blight that UI is allowed to occur at this site is just drawing more crime to the English Station area. I'd also just like to point out that nowhere in the PCO is there a limitation of $30 million on UI's exposure for the remediation. The remediation goes all the way up, whatever it costs. The only limitation in the PCO is that UI has agreed not even to petition Pura or any other party for partial remuneration of any expenses unless those expenses go above 30 million. I can't speak to you about why there was a delay and why it has taken 7 years, but there has been 7 years. There's no evidence in the record, but I might cite, you might make an inference that that additional exposure may be slowing down their response, which is still a violation of the PCO. And again, to be clear, as Attorney Wheel said, we don't have to worry about whether you have general jurisdiction under 1611 or 16.9 about what this company does and things that are outside of rate base, what their commitments to the state are. We have that merger agreement, the merger agreement where they agreed to implement the PCO, to have it done in time, i.e. 3 years. 7 years later, that has not been done. That puts it squarely within the jurisdiction of the Pura. And again, I would echo Mr. Wheel that this is an appropriate place for, you do not need an extra proceeding. You have one available to you. And the best part of this is that it is actually an ROE penalty that can be lifted upon completion of the remediation. It makes more sense to do it here today than it would be to hold an independent proceeding. You could, but you don't need to, and you're doing it in the proper venue. If you have any questions, I'd be happy to answer.
No, thank you.
Thank you.
Who did I call next? Attorney White? Nothing. Thank you. Attorney Goodman? Nothing. Thank you. Was not Attorney Bogan. Thank you. Which leaves us with Attorney Cook, I believe. Okay. Very good. That brings us to the conclusion of today's oral arguments in this proceeding. I will say that on behalf of my fellow commissioners, we will take under advisement the written exceptions in the oral arguments provided here today when considering the final decision in this matter. So with that, we are adjourned and thank you for your participation.